Lordship, may I be permitted to mention a matter? It's a second appeal matter for listing this matter.
Okay,
Lordship, I have,
month of January.
Lordship, I have filed an which was have to be listed on today's list, but it was not listed.
Anyway, it
Kindly,
will
the
happen.
extension, Lordship, the urgency, the extension of the order is expired.
Is it an extension of interim
Yes,
order?
yes, yes, Your
Okay,
Lordship.
to be mentioned tomorrow.
Lordship,
Maybe
permitted
if to mention, my lord, motion mistake, my lord, it was in the list of Justice Order Bandyopadhyay. And the
No, no. Under which category?
MSCC mamla.
No, MSCC ready for hearing.
No, my lord.
Then
Motion is staying. September 2024, it was filed. My learned friend appear on behalf of the rest.
whatever it is, it will appear in the month of January.
Lordships kindly appear to.
You see, next 2 weeks this bench will not sit. So whatever it will appear in the month of January.
Your Lordship may be permitted to mention one matter. Your Lordship, this is a second appeal matter for delay matter. The Lordship has been filed.
Condonation of delay.
Condonation of
Okay,
delay.
month of January.
Only 2 days, Lordship. Only 2 days delay is there, Lordship.
Whatever it is, you see, actually there is no such urgency, section 5.
I do understand, Lordship.
Let it appear in the month of
I do
January.
understand, Lordship, but there, Lordship, there is a preliminary decree on this matter.
Yes.
The preliminary decree says within 90 days from the decree, if there is no amicable settlement, then there will be final decree.
No,
For
you have
that-
challenged that preliminary decree. Whatever it is, it will be taken up. In the next month, it will be taken up. Section 5 has to be taken upon service upon all the parties. So in the meantime, you cause service upon all the parties.
Your Lordship, we have serviced to Kanai Ghodai, the main opposite party.
Whatever it is, you take steps so that all parties are served, so that there is no such dispute.
May I have lordship to mention one appeal which was disposed of by local order. But my lord, the one application is to move my lord, the earlier local order and the ensuing local order. But the
So that record has to be sent.
No, my lord, the file has been displayed. Kindly ask the my lord, the concerned FMA section to submit.
Anyway,
by Thursday
let it appear as to be mentioned.
on Thursday, and the manner the file my request to report from the concerned FMA section that the file is
Anyway, let it appear.
has to be mentioned on Thursday.
Yes.
May I have my last limit to mention one application claim cases. Let us.
জায়গায় টু বি মেনশনড থাকুক, তারপরে টু বি মেনশনড করে একটা
To
রিকনস্ট্রাক্ট।
be mentioned in reconstruction, FMA section থেকে একটা রিপোর্ট দেবে যে ফাইল নট ট্রেসেবল, যেমন গতকালে একটা অর্ডার হয়েছে। হ্যাঁ, এটা শুদ্ধি পাচ্ছি।
Not listing of an application has to be mentioned.
Yes.
Claims. Grateful, Judge.
I have you kindly to mention 2 applications, my lord, in connection with second appeal.
Okay, the month of January.
Lordship, application.
Application, yes.
Or include, my lord.
Hearing. Application.
Application is there.
Yes.
Your Lordship, I would like to mention a case.
Mentioning for?
Mentioning for staying the executing proceeding.
Okay.
Number 3.
Yes, pass over.
Let it be heard.
My lord, I am appearing on behalf of the respondent 124 claimant. My lord, my senior is ready. Just fix the matter next date for hearing, my lord.
Let it be fixed in the month of January, madam.
Yes, record an order. Learned advocates for the parties are present. It's a 2011 matter.
My lord, it's a murder case, my lord.
Okay. This is an learned advocates for the parties are present. Let this matter appear on 13/1/2026.
Number 4.
Pass over. Yes.
My lord, in this matter,
My lord, kindly go to the order sheet. On 14/6/2019, the stay order was obtained, and according to that stay order, we deposited 6,95,925.
No,
We
is the matter ready for hearing?
My lord, let me. I mentioned it particularly because we have obtained stay, and after that it was dismissed for default, and a restoration application was filed, and it was restored. And again, the department gave a note that certified copy of the impugned judgment was not filed. That was a defect, and in that event. 12/2/2025.
Let me see the order.
Thereafter, this on 4.
Now this appeal is restored to file.
My lord. Then again,
Yes.
on 4/4/2025, my lord.
4/4/2025.
My lord.
Let me see this order. Four 2025 এর অর্ডারটা বার করুন।
আমার কাছে আছে প্রিন্ট।
Yes.
My lord, this was not suppression, though it was written suppression. The erstwhile
So
advocate.
7th March 2025, that order was recalled.
Yes, my lord. And the stay order is there, my lord. And we have deposited the entire awarded amount.
The question is, you see, if an order is passed, what do you want now? To call this order. So that you have to obtain.
This order may be recalled and the stay should continue, my lord.
So get it recalled from the bench which has passed this order.
What is the difficulty is because they are not appearing before this honorable court, and they are.
No.
My lord, let me.
See, you want this order, come with an application. How can you pray for recalling?
We are not able to get the certified copy because the learned tribunal is saying that the TCR has come, and here I have checked the record that TCR has not come, and tomorrow is the execution date. The respondent claimants are not willing to come here.
Yes, record an order. Learned advocate for the appellant is present. As the learned advocate for the appellant submits for recalling of the order dated 4/4/2025, and for a further stay, learned advocate is granted liberty to come with necessary application for recalling. Stop. As the matter is sub judice before this court, the appellant is granted liberty to pray for adjournment before the learned trial court / executing court, which may be considered. Let this matter. You file an application, then you mention liberty to mention.
I'm grateful, man. I'm grateful. This order may be uploaded urgently, my lord.
Yes, it will be uploaded.
My lord, because tomorrow is the date. It may be uploaded today only, otherwise.
Yes, it will be uploaded. এটা পাঠিয়ে দেবেন ফাইলটা তাড়াতাড়ি।
I'm grateful, ma'am.
5 and 6. Your Lordship, kindly see the order dated 1st December
Lord,
2012. Down go to the.
my lord,
My lord, this is my appeal.
my lord, my lord,
No,
let-
what is this? What is this order?
my lord,
December 2000.
my lord, let me submit today was the date for filing the written argument by me, my lord. I am running fever just because of the previous matter.
Are you ready with your written notes of
No,
argument?
my lord, I am running with fever, my lord. I could not come yesterday also.
Your
My
Lordship,
lord, I'm
kindly hear
just
the
because of the previous.
December, my
Okay,
lord.
where is the, let me see the order, previous order.
The 1st December 2012.
Again order.
Where my lord,
তোমার
I
জ্বর হোক
completed
তারপর-
my argument with
Okay.
compilation of judgment.
Just a minute,
In
just a minute.
spite of that, at her instance, my lord, he prays for filing written notes of argument. And your lordship was pleased to grant, both parties are directed to file written notes of
Question
argument.
is,
Now, my lord, I.
okay, today the matter is appearing for to be mentioned. Oh, yesterday, the matter was due to appear as to be mentioned. Okay.
Kindly grant me leave to file a written
Yes, I'm
notes of
granting you leave. Let your learned friend also file day after tomorrow.
My lord, next Monday I am running with fever, my lord. I just cannot.
Then I have to keep it in the month of January because 2 weeks this
My
week
lord,
will
it will
not
be
see.
better, my lord, because I am not able to just because.
Yes, record an order. Can you file it by Friday?
My lord, I will try. I will try. I don't know, my lord. I'm
My
having a
lord,
terrible headache.
My lord, today I am filing, my lord, in both appeals, both.
Yes, sir.
January, my lord.
Learned advocates for the parties are present. Today was fixed for filing written notes of arguments. Learned advocates for the Clement's appellants in FMAT 38 of 2023 has filed written notes of arguments. Let it be kept with the record.
Both appeals.
Learned advocate for the insurance company prays for time to file the written notes of arguments. Time is granted. This Friday or
January, my lord.
the
Kindly.
time to file written notes of argument stands extended till 5/1/2026.
What is
My
the
lord, in the two
what was the
appeals,
name?
two written notes of argument filed today be kept with this.
Yes, I've recorded that.
I'm get.
I'm grateful, my lord. Date ta ki diben? I'm grateful.
Order 7. My lord, I am for the claimant respondent. Kindly send the matter to the National Lok Adalat for action.
Yes, record an order. Learned advocate for the respondent is present. As there is a chance of settlement in this claim case, the matter is referred to the National Lok Adalat to be held in the month of December. Fix 13/1/2026 for report of the National Lok Adalat.
Number 8.
Your Lordship, Advocate Yogesh Kumar Sharma appearing for the appellant. He is suffering from high fever. I'm praying for not this week, Your Lordship.
Okay, not this week.
Number 9.
Yes, my lord. I am representing the claimant appellant. You know, this is a claim case arising from the railway accident case, and this matter is ready for hearing. So any date.
So paper books have been filed.
Paper book I have filed, I have also served.
Yes, record an order. Learned advocates for the parties are present. It is submitted by the learned advocates that the matter is ready for hearing and the paper books have been filed. Let this matter appear for hearing on 6/1/2026.
Grateful to your lordship.
Number 11. Number 10. Sorry. 10 mother appear for the appellant, my lord. For correction.
What is to be corrected?
I have not mentioned my lord.
Excuse me.
Oh, gotcha. Yes, record and order. Learned advocate for the appellant is present. This matter was referred to the National Lok Adalat by order dated 1/12/2025. Stop. This matter was directed to appear on 7th December 2025 for report of the Lok Adalat. Stop. Let the date be corrected, and instead of 7th December 2025, it should be 7th January 2025. Other contents remain unaltered. So it has already been referred, only the correction of the date. 7th January 2026.
ঠিক করে না একবারে নতুন বছরে ফাইল করো আমার রিভিউ করতে পারবে না আমার 11 মানে আইটেম নাম্বার 11 মানে both sides are present মানে kindly make it মানে not this week মানে because
Okay, not this week.
well
In my opinion. ক্যানটা পাওয়া গেছে? ক্যান টু
My lord, I am for the insurance company.
Yes.
Matter
What
is
is
ready
this
for hearing.
application?
matter is ready for hearing. Paper is there. I filed an application
Yes.
for some correction in the
Post
title.
in the memo of appeal
In the memo of
1203.
as per paragraph
As per paragraph 3.
My lord, my lord. My lord, there is a Meena Shah. It will Meena Devi.
Double Kishore Saha, Kishor.
Kishore. Yes.
Yes, record and order. Learned advocates for the parties are present. The application CAN 2 of 2025, which is filed for causing necessary amendments in the cause title, is taken up for consideration. Heard learned advocates, peruse the petition filed. Stop. As the amendment stroke correction sought is formal in nature, the same stands allowed. Let the name of the claimants number 4, claimant number 6, and claimant number 7 be amended and changed as mentioned in paragraph 3 of this petition. Stop. The department is directed to carry out this amendment within a period of 2 weeks. Liberty to mention.
Matter is not ready. As your lord. Matter ready for him. Paper was filed.
Anyway, you mentioned after the amendments have been carried out.
My lord.
Lordship, I appear for the petitioner. Mr. Supratim Laha was arguing on this matter. Lordship had was hearing him, Lordship. So today he's on his legs in courtroom number 39, your Lordship. I was praying that
Okay, not today.
Lordship may fix it on Monday any day because the other side is there.
I can, because you see, Monday this bench will not sit.
Lordship, then any day.
Then month of January.
Lordship may kindly fix a date and time because Lordship may, because we need some time to finish our arguments and then they need to.
They had already majority of their arguments.
No, some part is still left. Lordship was hearing Mr. Laha.
Kindly keeps it in this month, your lordship.
Lordship will not be sitting.
Only few days are available. Okay, it is not possible to complete. So
Lordship, we need some time to complete.
Learned advocates for the parties are present. On the prayer of learned advocate for the petitioner, the matter stands adjourned till 6/1/2026.
Lordship, and Lordship may fix a time so that.
6 তারিখে কোনো ফিক্স আছে ম্যাটার? হ্যাঁ, আছে। It is already in an upgraded position. Let it retain its position.
Lordship may kindly fix a time, then we can
No,
finish
it
up
will
our
be taken
argument.
up. It will be taken up in the morning. আচ্ছা, এই 6 তারিখে কোনো দেখুন তো। তিনটের সময় থাক তাহলে। Yes, 6/1/2026 at 3 p.m.
Grateful, Your Lordship.
3 p.m. I appear for the petitioner, my lord.
Your Lordship, I am appearing before the opposite part. Led by Mr. Shonak Bhattacharya, Your Lordship, is engaged in courtroom number 8. Lordship.
In that event, my lord, I have no difficulty, my lord. Then kindly keep it in the month of January, any date, my lord. Because
আচ্ছা, ওই ওই আগেরটাই যা অর্ডার হলো একই অর্ডার করে দেবেন, টাইমিংস ওই তিনটের সময় থাকবে।
only one difficulty, my lord, the interim order is till the end of this month, my lord.
আচ্ছা, ওটা করলেন তো? ওই আগের যেটা ছিল ওইটাই থাকবে। The interim order stands extended till 23/1/2026 or till further orders, whichever is earlier.
End of January,
23/1.
as your lordship. Deeply obliged.
Number 16.
For the petitioner, lordship, Mr. Singh is appearing for the insurance company. This is
Yes.
application for condemnation of delay in
Yes.
filing the appeal, your lordship.
Yes, give me the records.
The son of the appellants was died.
Pan old is 10881.
Lordship, that was the
Old number.
old number. The new number is
তুমি শুধু রোগাই হবে না, অ্যাপ্লিকেশনের কপিটাও দেবে।
copy.
Have you served copy upon your learned friend?
My lord, I am appearing on behalf of the respondent, insurer, my lord.
Yes, this is এই নতুন ইয়েটা পড়েনি তো, নতুন নাম্বারটা পড়েনি এখানে। হ্যাঁ, হ্যাঁ, কিন্তু তাহলে কপি নিতে হবে। একবার তো অ্যাফার্ম হয়ে গেছে এটা, তাহলে আবার কেন ইয়ে করবে, ফাইল করবে?
নতুন নাম্বারটাও পড়ে
2017।
পাওয়া যাচ্ছিল না।
তাহলে 2017-তে যারা ফাইল করেছে
ফোনটা পেয়ে
তাদের
গেছে,
নাম্বার
তখন তো দেওয়া
অটোমেটিক
দরকার
পড়ে
ছিল।
গেছে। 2017 be treated as disposed and a new registration number be allotted to this particular application by the section.
Your lordship, only my lord, take note of, my lord, the number of days delay they are praying for. My lord is kind enough to condone, my lord. In our case also, my lord, we may be coming up with such
658 days is the delay, 600 days.
That's what I say.
That
my
means
lord.
more than 1 year.
More than 1 year, 2 years. Obliged, your lordship.
So, sure, only one direction also the
Oh, the delay is condoned, the appeal is admitted.
lordship,
As learned advocate for the insurance company has appeared, service of notice upon the insurance company is dispensed with.
Lordship.
so itself be called for and kindly
The trial court records be called for.
and the paper will be prepared by myself, your lordship.
Anyway, let the trial court's records come. বলে দিচ্ছি to allot a new number by the section.
So kindly fix a date after the vacation, your lordship.
You liberty to mention.
Your lordship.
Obliged, my lord.
17.
তো দেবেন এখনো দেবেন না
দৌড়চ্ছে
Yes.
This is an application for substitution. One is within the period of limitation. Another is there is a notice.
You are for the appellant.
I am for the appellant, my lord.
So respondent has entered appearance.
Yes, Mr. Mondal is there. We have served notice upon him. And he is on his way. And if your lordship can turn to the
This
application.
item number
3 of 2025 target in lordship. 17. Paragraph 2, your lordship will find.
No, this matter is already admitted.
Yes. By the division bench. After that, my lord, just
That is referred to hearing.
hearing and connected applications are to be.
So shall I pass it over? You can mention if the other side comes.
The substitution within period of limitation. So there is no formal. As it your lordship, my lord.
Okay, I am passing it over. If he does not turn up by 12, you mention.
As
Or before rising, if he does not turn up, you mention. Or even if at 2 p.m. also, you can sub notice come at 2 p.m. also.
As your lordship.
Item 18.
18, my lord, I am appearing on behalf of the opposite parties, my lord.
My lord, I am for the appellant insurance company, my lord.
Opposite parties,
My lord, we have served.
My lord, first, my lord.
My lord, the affidavit of service.
Item 18.
Affidavit of services here. My lord, you have already deposited the amount 25. Let me finish.
No. First, my audience, my lord.
25,000 we have already deposited. Lordship, they have filed the execution proceedings. Now, my lord, I am praying for stay of the operation.
Yes.
My lord, first, my lord, the claimant respondent number 2 has already been died after the passing of the judgment, my lord. My lord, so my lord, his name may be strike out, my lord.
So come with an application.
Come with the application.
Come with an application.
No, my lord.
Let the appellant come with an application. Okay, you intimate him in writing, giving him the years. He will take out an application.
No, my lord, all are in the.
Oh, they are already in the record. So give it by way of application instead of filing that.
25,000.
25,000.
It's statutory deposit.
Okay,
So we are praying for stay.
My lord, no, my lord. If no stay, my lord. Actually, my lord, they have admitted in paragraph number 7 that the claim is, my lord, admitted 6,25,500, my lord, my lord, and that calculation is wrong, my lord. This calculation should be, according to the insurance company, it should be 8,68,500, my lord.
Now,
Payment of that, my lord.
Just a minute. First of all, let this. So the other years are already in the record.
2 claimants are there.
Yes, record and order.
2 claimants are there, my lord. 1 has already been done.
After
passing of the judgment.
All the parties are present. Heard learned advocates as learned advocate for the respondent number 2. Respondent number 2 submit that the respondent number 2 has passed away and his legal heirs are already on record being respondent number 1, Babli Bibi Sheikh. The names of the respondent number 2 be deleted from the cause title. Stop. The department to carry out necessary amendments within a period of 2 weeks. Stop.
My lord, delay may be condoned, my lord, 11 days delay.
Okay. Where is your application?
Can 1, my lord. And stamp reporter also said 11 days.
Okay. The application for condonation of delay is taken up for consideration. How long is the delay?
11 days.
What do you say?
No.
Upon hearing the learned advocates and considering the petition, this court is of the view that sufficient ground is shown for condoning the delay. Thus, the delay in filing this appeal is condoned and the appeal is admitted.
My lord, stay may be granted for.
Just a minute.
My lord, stay may be granted after payment of the admitted amount, my lord. Admitted amount,
Learned-
paragraph number 7. my lord.
Learned advocate for the submits that the appellant insurance company has already deposited the statutory amount of rupees 25,000. Stop. Learned advocate files the challan showing deposit of rupees 25,000 on 4/11/2025. Stop. In the facts and circumstances, there shall be an ad interim order of stay of the judgment and award passed by learned judge, bench 11, City Civil Court, Calcutta, in MSC case number 190 of 2020 for a period of 5 weeks from date. Stop. The appellant insurance company shall take steps to deposit the entire awarded sum along with interest as directed by the learned trial judge within 5 weeks. Stop. Excluding the statutory amount. In the event the awarded sum is deposited along with interest, the interim order of stay shall continue till the disposal of this application. Liberty to mention.
I'm grateful.
My lord, I am already prayed, my lord. The admitted amount may be allowed to withdraw, my lord.
No,
Come on the next necessary application.
You have to file an application.
Otherwise, I can do one thing. Do you want to go to Lok Adalat? I can send the matter to Lok Adalat if you so desire.
My lord, let it be here.
If you want to settle, I can send it.
I'm only saying that some portion of the amount has already been added.
Very well, you settle that. If you want to settle that with that amount, you can go before the Lok Adalat and settle it.
লোক আদালত হবে না কারণ
13 is the law.
Can
Day
I-
of the Lok Adalat. My lord, 13 is the
Huh?
day of the Lok Adalat.
Till further orders.
I'm grateful, my lord.
না না একটা ডিসপোজ হয়ে গেল আর একটা তো পেন্ডিং থাকলো.
I'm grateful, my lord.
Okay, you mentioned afterwards.
May be allowed to file an opposition of the.
Yes.
May be granted a opportunity to file an opposition of.
Yes, yes, that liberty is already always there.
19 and 20. Next.
I am appealing in 19, my lord, as respondent claimants, and 20, my lord, I have filed the appeal, my lord, against the same judgment and award. Sucharita Pal appearing.
Okay, not today.
My lord, better Thursday.
Yes.
Day after tomorrow.
Okay, not today and tomorrow.
I will mark it. কালকে বলেছিল পরশু।
Yes, Passover matter. Are you ready? Yes. Call the Passover matter.
I heard the respondent, my lord.
17.
Substitution application. I
Yes,
have
yes,
not-
yes. Give me the records.
17 years.
So, which respondent died?
No, appellant. Sole
Appellant.
appellant.
Oh, appellant.
Nizamuddin Mustafa died.
This
on
is a sole appellant.
sole appellant.
Okay, and who are the applicants? This is the applicants.
Yes, the years of the applicant's repeated lordship being the
Okay, when this appellant died?
14th May 2025. I have annexed the death certificate and just filed on 5th August 2025.
14 May 2025.
Yes, my lord. I have annexed the
Death certificate.
death certificate, page 27, my lord will find.
Page 27.
My lord got it. 14th May 20.
Okay, within 90 days you have filed.
Yes,
Yes, record an order.
The period of limitation.
Learned advocate for the appellant and learned advocate representing. You are for all the respondents. For the respondents are present. The application for substitution being Can 3 of 2025 is taken up for consideration. Hard learned advocates peruse the petition filed. This application is taken out by the heirs of the sole appellant Nizamuddin Ostagar for recording his death and for an order of recording the substitution. Stop. The appellant Nizamuddin Ostagar died on 14/5/2025. Stop. As this application for substitution is filed within the period of limitation, the same stands allowed. Let the name of the sole appellant be deleted from the cause title and the names of the applicants be substituted in his place and state.
Mentioned in paragraph 2 of the application.
Name of the applicants, applicant stroke legal heirs mentioned in paragraph 2 of the petition be substituted in his place and state. The department to carry out the necessary amendments within 2 weeks. Liberty to mention.
And another application stay was there for limited period. After remand, it has been accepted before the trial court. Initially, identity order was there. Because person death, we could not take steps. The application is still pending. That is can number 1 of 2024.
Okay, the interim order of stay
all for the,
granted earlier shall stand extended till 23/1/2026.
Now the appeal will be hard. Well, appeal has been admitted. So
anyway, you mention the matter. On the next day, I shall make it absolute.
As
I'm extending it up to 23rd January.
As your lordship, please. Grateful to your lordship.
No, 21. 21.
I'm for the appellant.
My lord, I am happy about the respondent claimant. Today I am filing the paper.
What is this scan one? Scan one is the stay. Interim stay was granted, your lordship granted interim stay on 6th November 2025 and directed my client to deposit the entire awarded sum together with interest. I have secured the said sum. This is the copy of Chalan Malat. Kindly make the stay absolute. Yes, record. Yes, record an order. Learned advocates for the parties are present. As the appellant insurance company has deposited the entire awarded sum along with interest in terms of the order passed by this court on 6/11/2025, the interim order of stay granted earlier shall continue till the disposal of this appeal. Stop. My learned advocate is filing paper book. The paper books filed by the learned advocate for the respondent claimants be kept with the record. Let this matter appear for hearing on 14/1/2026. stay আছে দিয়ে দিতে
Let 22 have appeal for the appellant, my lord. This is an application, my lord, for appropriate order in a sense, my lord, for implementation of an order of injunction in the form of status quo passed by this honorable court after admission of the appeal, my lord. In the meantime, my lord, the appeal is otherwise ready for hearing. Paper books have been prepared, my lord. If your lordship kindly sees lordship kindly sees, my lord, at the time of admission of hearing, there was a limited interim order, which was subsequently, my lord, made absolute by the honorable judge.
So what is this? Can 2?
Can 3.
Can 2 is disposed. And can 3?
Can 3 appropriate order.
But can 2 is pending. Can 2 is for additional evidence.
Can 3
No. Can 2 is pending. That application
So
is
that
for
has to be decided along
the
with
time of
appeal.
case, my lord, there was an order to that extent. Can 3 and can 4 are substitutions after setting aside amendment, or does been disposed
So
of?
those are allowed.
Those have been allowed, my lord.
Now the question is, let the appeal be heard out.
My lord, subject to what my learned
Paper books have been filed.
It's been filed, my lord.
Yes, record and order. Learned
I will check the records. If not filed, my lord, I will make sure, because I have the copies of the paper book with me. Because I will just ensure.
Okay, learned advocates for the parties are present. It is submitted that by the learned advocates that the paper books are ready. Let the paper books are ready. Let the paper books be filed on or before 6/1/2026. Let this matter appear on 6/1/2026 under the same heading.
6/1 for hearing of the appeal.
Because, my lord, in this case, my lord,
For filing paper books?
My lord.
And my matter will appear for hearing.
6/1/2026.
My lord, I shall take some time because my lord.
6/1/2026 under the heading to be mentioned.
Yes,
you file your paper books, the date of hearing will be given.
Number 33.
23, my lord, 2 applications are pending, my lord. My lord, one is, my lord, under Section 5 of the Limitation Act, and the other is, my lord, for addition of party. My lord, both the application, my lord, needs to be served, my lord. There has to be a formal order. My lord, first time. My lord,
application for condonation of delay has to be heard.
Has to be served, my lord. My lord.
No, is to be heard in presence of the both of.
Yes, certainly, my lord. My lord, I'm seeking a direction for service.
Yes, yes. Record an order.
Both the applications, my lord.
Learned advocate for the appellant is present. The application for condonation of delay and the application for addition of parties are taken up for consideration. As copies are not served upon the opposite parties, let copies be served upon the opposite parties, stroke respondents, within 3 weeks, and affidavit of service be filed. Let this matter appear on 13/1/2026 under the same heading.
My lord. My lord, kindly, my lord, makes it, my lord, respondents number 1 to 6. Since, my lord, the plaintiffs are 1 to 6, I am one of the defendant in the suit, and the others are, my lord, pro forma respondents.
Okay, you cause service. If they don't appear, I shall see.
I'll do it, my lord. Grateful.
Twenty-four, my lord, I am for the respondent number 1 opposite party in the Section 5 application. There is a delay of 2,211 days. The affidavits are complete. But,
appellant is not here.
In that event, my lord, your lordship post it any day after 15th.
After?
15th of this month.
So this bench will not be available after 15th.
Then my lord, make it after. Oh,
okay.
Oh, নেই তাহলে স্যার আফটার ভ্যাকেশন করুন স্যার জজ সাহেব থাকবেন না
Then, my lord, kindly take it after vacation.
Yes, record an order. Learned advocates for the parties are present. On the prayer of learned advocates, the matter stands adjourned till 6/1/2026.
Grateful.
আমি পিটিশনার
না ঠিক আছে ও পিটিশনার তো টেকনিক্যালি হি ইজ কারেক্ট আই ওয়াজ রং
25.
Malad, this is my application. I am the respondent number 1 in the appeal.
Can 1.
Can 1 in SAT 250.
SAT?
250 and can 2 in SAT 249.
Yes.
Your Honor, this is an
You
application.
are the
I am
respondent.
the respondent number 1. May I kindly indicate there are 2 appeals.
Yes.
In one appeal, my learned friend who is appearing for the appellant has preferred an application for stay. There was an interim order which was granted. That can be confirmed. And I have preferred 2 applications in both the appeals for preparing the paper book, because they are the appellant. They are enjoying an interim order. They have not taken any steps for preparation of the paper book. I want the appeal to be heard out. So let there be a direction upon the respondent for preparation of the paper.
So what is this can 1 for?
Can 1 in 250 is an application taken out by me. Your Honor is
No, there's can 1 and can 2 in both the appeals.
Yes.
So in can 1, can 2 of 249, it
Yes.
is your application.
Yes.
And can 1?
It is also his application. No. Can 1 in 249 is their application.
For stay.
For stay.
Anyway, so, and so far as this 250 is concerned, can 1?
250 can 1 is my application. There was no stay because...
For filing the paper books.
Yes.
Yes, record an order. Learned advocates for the
Service of notice of appeal.
parties in both. So, in both the cases, there is only sole appellant and sole respondent.
No, not sole.
Okay. In both the cases,
I am the
you are representing all the respondents.
I am the contesting respondent.
No.
And Your Honor,
SAT 249, you are representing all the respondents.
No, my lord, may I clarify, my lord?
Yes.
Kindly takes up, my lord, any one of the can 1 in 250.
Okay, can 1 of 249.
240. No, can 2 of 249.
Okay, can 2 of 249.
Yes.
Can 2 of 249, your lordship takes it up.
Yes.
My lord, your lordship will get, my lord. I am representing, my lord, the appellant.
Appellant defendants.
Yes. Plaintiff appellant. My lord, it's the respondent number 1. My lord, I am the appellant in this present appeal. My lord, who is the opposite party number 1?
Okay, that means you are the in the title suit, you are the plaintiff.
Yes.
In the before the first appellate
Before
court.
the second appellate court.
So, first appellate court, you are the respondent number 1.
And
And
here
before
appellant.
the second appellate court, you are now the petitioner.
Yes, appellant
Yes.
petitioner before
Yes,
my lord. Now, my lord, kindly takes up, my lord, the order of admission that is at page 9 of my lord's, my lord, application.
Yes, page 9.
My lord, if your lordship takes up page 13, because I am not traveling, my lord, regarding the other part, your lordship will get, my lord, since the respondent number 1, who is the applicant before your lordship, he appeared on caveat. So, service of notice of appeal in
Has been
respect of
dispensed
his
with.
dispensed with. So far as regards the rest of the respondent is concerned, the notice of service of appeal needs to be, my lord, served. That is one aspect. And thereafter, whatever my learned friend is suggesting.
So far, this 249 is concerned, you are appearing for respondent number 1.
Yes.
I am for
Okay. So the service has to be effected upon respondent.
Rest of the respondents in the appeal.
Yes.
And thereafter, whatsoever my learned junior is not asking for
Yes.
before your lordship, so far as regards the preparation of paper book and other, that your lordship can allow. But I am not standing in.
Your Honor, the records are already here. They are the appellant. They are now sitting on that interim stay. Now it was upon them. The carriage of proceedings is completely upon them. If they do not want to...
Burden to file paper books is also upon them.
Yes.
That is
Yes,
direction is yes passed.
Yes, record an order.
What my learned friend is sitting, I am sitting over.
Learned advocate for the appellant in SAT 249 of 2000. আলাদা করে কোনো SAT 249 of 2024. And learned advocate representing the respondent number 1 caveator are present. The respondent number 1 has prayed for leave to file the paper books. Stop. In the application can 2 of 2025. Stop. Such leave is granted. The paper books be filed on or before 13/1/2026. Let this matter appear on 15/1/2026 under the heading to be mentioned.
But so far as regards the service of notice
Yes.
of appeal is concerned, yes.
The appellant shall take steps to cause service of notice upon respondent number 226 as already directed by order dated 5/3/2025 through the department.
Lord, only one thing, my learned friend have Lord contended that regarding the application, interim order is still the disposal of the application for that is can be made complete, my lord.
Let this matter, আচ্ছা পড়ুন তো একবার কি বলে লিখেছি। হ্যাঁ
তাহলে তুমি হ্যাপিলি হারিং করতে পারবি না, আমার কি আছে। হ্যাঁ চলছে এটা।
For service of notice given as well 6 as already directed by order dated 5/3/2025 to the department.
To the department. The interim order granted earlier shall continue.
My lord, it's still disposal of the application. Your lordship can made it till disposal of the appeal.
No, how long? It is continuing.
Yes, till disposal of the
Okay,
application.
the interim order of stay granted earlier shall continue till the disposal of this application.
Application already granted, my lord. Your lordship made it till the disposal of the appeal.
Till the disposal of the appeal.
And
Lord,
that
so can one can be disposed of.
Can one
can two,
of
and can three, all can be disposed.
all can one, and this is only can one and can two.
Can one and can two.
Can one of 2024 and can two of 2025 stands disposed. Achha, now next case 250. 250 record ta din.
So far as regards the 249 can one is concerned, this is the affidavit of service. Not let it be kept on record.
আচ্ছা ওখানে একটা করে দেবেন তো, the affidavit of service file be kept with the record.
যা চলে যা, আর তো কিছু নেই, আমি বলে দেবো।
With your honestly, may I?
So let him go, my lord. One matter has been called on. I am here. এর ফাইলে খালি এই ক্যান ওয়ান এর এফিডেভিট অফ সার্ভিসটা যাবে।
Yes, learned advocates for the this is 250.
250 my lord.
Learned advocate for the appellant and learned advocate for your respondent.
The appellant?
No, in 250.
250 also, my lord, I am the appellant.
Learned advocate for the appellant and learned advocate for respondent number 1 is present. Acha, they let the same order be passed.
Same order.
একই order করে দেন।
Only injunction is not here. The injunction order which has been your lordship made absolute till the disposal of the appeal, that portion will not be here.
স্টে অর্ডারটা দেবেন না, কিন্তু ওই ডিসপোজাল হয়ে যাবে, ওইগুলো ডিসপোজ হয়ে যাবে। ক্যান ওয়ান অফ 2025 stands disposed.
Only one, yes. I'm grateful. Stop disposed. Great.
26টাতে শুধু ওয়ানই আছে।
হ্যাঁ, only one.
I am for the appellant.
Yes, which application? Can one?
Can one, my lord. এর মধ্যে এপিডি সার্ভিসটা এর মধ্যে আছে, কালকে দিয়েছিলাম এপিডি সার্ভিসটা এর মধ্যে ঢুকে গেছে। হ্যাঁ, এপিডি সার্ভিস দেখো একটু খুলুন, এটা well I have sub my lord, they have received, this is the service my lord. Can one, my lord.
How many days delay? 600.
616 days, my lord. The date is fixed on 15th of this month, my lord. The very interesting case, my lord.
I inherited 8.5 share and to partition I was entitled to 4.5. The landed.
No, just a minute.
My
The
lord.
appeal is not yet admitted.
No, my lord.
So whatever this stay and everything you have to move. Oh, this is also section?
Section 5, my lord. Section 5 before your lordship. Can 1.
Section 5. One is 266. The
266.
by two application.
One is stay, one is section 5 application.
No, this.
Can 1 is section 5, my lord.
I am finding 2 copies of can. That
Lord,
means
perhaps
for 2 judges.
Inadvertently it has been filed. It will be 1 application for can 1.
Okay, so I can take up only can 1.
Can 1, my lord.
Yes, what is the affidavit of service?
My lord, it has been served.
How many respondents are there? 2.
2 respondents. 1 is ineffective, respondent number 2. And now.
Why ineffective?
Well, the state has nothing to do here, the BLL error.
No, you have served whom?
Both of them.
That is?
One is Mongli Murmu, the respondent number.
Page 5.
My lord.
Oh, the other is by how? How you have served? The state?
Let me check. Lord. এটা একটু দিন তো দাদা
এই না না এটা ওকে দিন ওই বার করে দিচ্ছি
সার্ভিসটা একটু কপি আছে কপি আছে কপি
That means 2 parties. That is the private party and the state.
Private party is the state, my lord. State has not been served, my lord.
So you have to serve the GP?
No, it has not been served upon the state, my lord. It has not been served.
When is the next date fixed?
15th is the date fixed, my lord. 15th of this month.
Achha, record an order. Learned advocate for the appellant is present. None appears for respondent number 1 in spite of service. The learned advocate for the appellant is requested to serve notice upon respondent number 2, State of West Bengal also, and also a notice upon the respondent number 1 intimating the next date fixed. Let this matter appear on 7/1/2026. Stop. As the matter is sub judice before this court, the appellant is granted liberty to pray for adjournment before the learned trial court, stroke executing court, which may be considered.
My lord, kindly add that line, but if your lord, it should say your lordship, lord, they kindly restrain them from taking any coercive step.
No, that is why adjournment.
Adjournment we will pray, lord.
Yes,
Your
that
lordship can visualize the court below, my lord.
That will serve your purpose.
Appeal service will be kept with the record. But service be kept with the record.
Yes, let the affidavit of service file be kept with the record.
Great.
Minute, I am for the petition. It's a contempt application. The first time it is appearing before your lordship. The order passed on 3rd of October 2025. Lordship was pleased to dispose of the application, my lord.
Let me see. What is the alleged contempt?
At page 17 of my application is the order of your lordship.
17.
17. এগুলোতে তো পার্সোনাল অ্যাপিয়ারেন্স করেছে কত করেছে কবে ফিক্স করেছে 3 weeks. ওনারা এইটাতে অ্যাপিল করেছে।
Yes, record an order. Learned advocate for the petitioner is present. Heard learned advocate for the petitioner. The petitioner, in the instant application for contempt, has alleged violation of the order dated 3/10/2025, passed in writ WPA number 23419 of 2025, where a direction was issued upon the contemner respondent to treat the writ petitioner to be qualified with regard to physical standard test. Stop. It is the contention of the writ petitioner that the respondent's contemners have violated the order of this court by not treating the writ petitioners qualified with regard to physical standard test. Stop. In the facts and circumstances, the petitioner is directed to cause service of copy upon the contemners within 1 week and file affidavit of service. Let this matter appear on 9/1/2026.
My lord, considered allowed and allowed the petitioner also in the detailed medical report, my lord. Detailed medical examination.
No,
The
your
order was
grievance is that there is a violation.
yes, madam.
Very well. You serve them and come.
My lord.
Twenty-nine.
29, my lord, same order, my lord. The order page at 17 and the ordering portion at page 8.
Yeah. It should be the same order. WPA number will change. WPA number, this is 23406
My lord, 23406.
of 2025.
My lord.
Same contemners.
My lord.
Achha.
Okay. 30 is also same.
Yes, 30.
406 now.
I think contemners are different.
My lord. The petitioner
Contemners are the same.
contemners are the same, man. The same recruitment process, all the petitioners in 3 applications, my lord, They were appearing in the same recruitment process.
No, names of the contemnants are different. Okay, contemnants. Anyway. আচ্ছা
যেহেতু same
যাতে
time.
একই ইয়ে করবেন WPA number 23409 of 2025.
এগুলো থাকে
Kumon Bishash.
এগুলো
Yes, it will appear on 9/1/2026.
হ্যাঁ, I'm deeply obliged to lodge. সবগুলো দেখি নয় 26
May I please, Your Lordship? Affidavit service merited 32.
Matter is ready for hearing.
Ready for
No,
paperwork. I need
paperwork is to be required.
filing of
That's why
paper.
the
For
evidence
Union of India.
Union of India, Railway, Eastern Railway. Paperwork is to be required for.
Hello,
Yes,
just
record-
after, just
proper
after, just
Yes,
after
record an
reopening,
order.
8th or 9th.
Learned advocates for the parties are present. The appellant prays for time to submit the paper books. Such time is granted.
Along with my evidence and cross-examination along with.
Oh, everything I
Entire,
can
entire.
I can
print the
incorporate
paper.
everything.
Whatever is to be
Yes,
filed has to be filed.
It is also for mine.
Let the paper books be filed on or before 5/1/2026.
Yes.
5th, my lord, let it be 7th.
Okay.
Let it be
13/1/2026. Let this matter appear for hearing on 15/1/2026.
Yes.
7th.
Developed.
Affidavit of service may be kept.
The affidavit of service filed may be kept with the record. Be kept with the record.
Deeply obliged.
This matter is fixed on 15th, my lord.
15/1.
15th.
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 33, 34, 35, 36, 37, 38, 39, 40, 41, 43 and 4, 45, 46, 47 and 8, 49, 50, 51, 52 and 3, 54, 55 and 6, 57, 58 and 9, 60, 61, 62, 63, 64, 65, 66, 66 to 68, 69, 70, 71 and 72, 73 and 2, 5, 6. 77, 8. 79 and 80, 81, 81, 82 and 3, 84, 85, 86, 87, 88, 89, 90, 91, 93, 94, 95, 96, 97, 98, 99, 100, 101 and 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20.
ঠিক আছে দুটোর সময় ফিক্স ম্যাটার তিনটে তো ফিক্স ম্যাটার আছে আর দুটো জাজমেন্ট আগে অরিজিনাল সেট ফিক্স ম্যাটার Yes, you are appearing.
Yes, sir.
Yes, hence this appeal is allowed in part. The judgment and award dated 19/5/2022 passed by the learned additional district judge, first track, third court, Shodor, Paschim Medinipur is modified to the extent that the appellants are entitled to rupees 39 lakh compensation from respondent number 1, ICICI Lombard General Insurance Company Limited. The respondent number 1 shall deposit before the Registrar General High Court, Calcutta, rupees 39 lakhs along with interest at the rate of 6% per annum from the date of filing the claim case till today. In the event amount awarded by the learned trial court is already paid, balance amount shall be deposited. Such deposit shall be made within 8 weeks from date. The deposit may be withdrawn by the claimant appellants upon compliance of all necessary formalities. Yes, call the fixed matter.
Fixed matter item number 2.
Made, please, your lordship.
Yes. Yes.
But your lordship may remember, my lord, on the last occasion I was placing, my lord, the impugned judgment. But this is a appeal against a judgment of reversal by, my lord, the first appellate court in a suit for, my lord, specific suit for recovery of possession by my learned friend on the ground of reasonable requirement. Now, my lord, their requirement was based upon the fact.
This is this matter, not that.
No, my lord, I was
matter.
also, yes.
Because that you appeared in that, it is the reverse.
Yes, yes. So,
yes, this eviction matter.
Yes. On the ground of, my lord, reasonable requirement and default was not decreed. The trial court had dismissed the suit, and, my lord, it was reversed in appeal. And, my lord, I being the tenant, my lord, I am in second appeal before your lordship.
Yes.
And my lord, the reasonable requirement was only for the office purpose by the plaintiff. And, my lord, they said that they are willing to accommodate, my lord, their office employees, and they are, my lord, in a licensed premises, and therefore, my lord, they are, my lord, under a threat of eviction by, my lord, the landlord in respect of the licensed property. So, my lord, this was, my lord, the ambit of their suit for which, my lord, they are seeking reasonable requirement. But I was
appellate degree. This is an appellate degree. In the appeal court passed an eviction degree.
Yes.
Yes. Yes, what are the points formulated?
Yes, your lordship will kindly come to, my lord, the paper book, my lord, page 129. Lord, these are the grounds, my lord, on which, my lord, the appeal was admitted, and your lordship is, my lord, deliver on this, my lord, the substantial questions of you.
Yes.
Whether the first appellate court has substantially erred in law in misappreciating the evidence with regard to the reasonable requirement in reversing the judgment and decree of the learned trial court, So this first question of law brings into its ambit, my lord, the reappreciation of evidence, my lord, in one way or the other. Whether the first appellate court has substantially erred in law in not considering Section 6(3) of the West Bengal Premises Tenancy Act with regard to the partial eviction of the appellant from the subject premises on the establishment.
Yes.
It is.
Yes.
But first, I take your lordship, my lord, to the trial court's judgment, which starts at, my lord, page 3 of the paper book. Lord, there is a compilation. Your lordship will kindly take the memo of appeal, my lord. The paper book. তিনটে paper বই আছে। The thinner one, the thinner one, the thinnest rather, yes. আর একটা না, আর একটু পাল্টা হবে একটা। ওটাতেই তো রয়েছে। ওটাতে নয় মনে হয়, না, ওটা
How
compiled.
many volumes?
There are 3.
3 volumes.
In fact, 2, Lord, we have compiled, Lord, the documents, Lord, for
Is
the
it
convenience of the
necessary in
court.
second appeal to compile everything?
In the paper book, Lord, your lordship will only get the
In
judgment.
first appeal, it is necessary to
First
compile
appeal, it is
everything.
necessary in view of the appellate side rules.
Yes,
But here,
second
Lord,
appeal,
we
it
have
is not
made this
necessary.
for the convenience of the court.
Okay.
So that your lordship do not have to refer to the lower court records, Lord, the trial court records nowadays, at every moment.
But the scope is limited only to that
Scope is
particular 2
limited.
points.
But so far as the first substantial question of law is concerned, Lord, that, Lord, takes me, Lord, or rather
Go to
gives...
the facts.
Yes. Because, Lord, it is an appreciation of fact on the question of reasonable requirement, for which, Lord, the appeal court had reversed a finding. So, Lord, whether the reasonable requirement has been proved by, Lord, the plaintiff before the appeal court, that is to be, Lord, looked into by your lordship. And, Lord, the other question was about the partial eviction, which is a point of law equally.
If apart from this any question is to be formulated,
then your lordship can do so under section 100 subsection 5 of the Civil Procedure Code.
Otherwise, that cannot be gone into also.
Lordship.
Unless it is formulated.
Lordship. Page number 3.
Yes.
But will kindly, Lord, I will just take your lordship, Lord, because reading this entire judgment will take some time. But I will just take your lordship, Lord, to the schematic portion wherein, Lord, the factual aspect has been let down. Therefore, Lord, thereafter, Lord, to the evidences and the finding of the reasonable requirement. Paragraph 2, the thumbnail sketch of the plaintiff's case is that the plaintiff is the absolute owner of flat number 1A on the first floor at Nilkant building, which has been more fully described in the schedule annexed to the plaint hereinafter referred to as the suit premises for short. That the defendant is a monthly tenant in respect of the suit flat at a monthly rental of 2475 payable according to English calendar month. That the plaintiff purchased the suit property from one Sri Sudha Baid by virtue of a registered deed of conveyance dated 18 November 2011. That after purchase, the plaintiff's vendor, Srimati Sudha Baid, sent a letter of atonement on 17 January 2012 to the defendant, directing the defendant to atone the name of the plaintiff and to pay rent month by month to the plaintiff directly. That in spite of receipt of the said letter of atonement, the defendant did not pay any rent to the plaintiff, that the defendant was originally a tenant under Sudha Baid, and after purchase, the defendant became a tenant under the plaintiff, and in spite of having knowledge the plaintiff was the landlord, defendant deposited rent at the rate of 2475 per month in the name of Sudha Baid at the office of the rent controller, Kolkata. It is a further case of the plaintiff that the defendant was inducted in respect of the suit premises pursuant to an agreement entered into between the previous owner Sudha Baid and the defendant on 15/5/1976. That from the terms and condition of the said agreement, it will be evident that the suit premises was let out for residential purpose. It is a further case of the plaintiff that the predecessor in title of the plaintiff had filed an eviction suit against the defendant, being ejectment suit number 524 of 1983 in the City Civil Code, Calcutta, and subsequently due to amendment of the City Civil Code Act, all the suits which were valued below rupees 30,000 were transferred to the Court of Small Causes, Calcutta. And the ejectment suit number 524 of 1983 was transferred to the Court of Small Causes, Calcutta, and was renumbered as ejectment 504 of 2001. It is further case of the plaintiff that Sudha Baid filed an eviction suit before the Honorable High Court at Calcutta, being CS number 1 of 2004. And in course of proceeding, it was adjudicated that the suit was filed in misconception of law, and the suit was governed by the West Bengal Premises Tenancy Act, but the suit was filed as per provision of Section 106 of the Transfer of Property Act. Subsequently, the said suit, being CS number 1 of 2004, was withdrawn by Sudha Baid on 10/4/2013 with permission of the Honorable High Court, with liberty to file a fresh suit. That subsequently, fresh notice was issued on 22/4/2013, and the said notice was duly received by the tenant on 25/4/2013. That in spite of receipt of notice of eviction, the defendant did not quit and vacate the suit premises, for which the plaintiff has been compelled to file the instant suit on the ground that the defendant is a defaulter in payment of rent in respect of the suit premises from November 2011, and that the plaintiff reasonably requires the suit premises for his own use and occupation, as the plaintiff is a non-banking financial corporation and has its registered office at 8 Kamak Street, Kolkata 17. It is further case of the plaintiff that the plaintiff has 9 staff employees in their organization, including manager and assistant manager, and that in terms of the service contract, plaintiff has to provide residential accommodation to the senior staff, namely manager and assistant manager. That since the plaintiff has given accommodation of their own for providing accommodation to the senior staff, the senior staff are provided rented accommodation on 11 months leave and license fees, for which the plaintiff has to incur huge cost towards payment of license fee every month. It is a further case of the plaintiff that the plaintiff wants to diversify its real estate and iron and steel business, and for which the directors and promoters have already invested 2.5 crore by way of share capital during the last 2 years, and for which more staff will be recorded. It must be read as required, and as per service contract, the plaintiff will have to provide residential accommodation to those staff also. The plaintiff has stated that the plaintiff requires the suit premises to provide residential accommodation to the manager and assistant manager. It is further allegation of the plaintiff that the defendant is using the suit property for the purpose other than for which it was let out, and that the suit property was let out for residential purpose, but the defendant is conducting speech therapy center, which is purely commercial organization from the suit premises. Plaintiff has therefore alleged that the defendant has acted contrary to the agreement of tenancy and is entitled to be evicted for being guilty of violation of clauses MOP of Section 108 of the Transfer of Property Act. It is the further averment of the plaintiff that the defendant has made several special conversion without obtaining any written permission from the plaintiff. The plaintiff has further alleged that the defendant is guilty of waste and negligence and causing material deterioration of the condition of the suit premises. The plaintiff has inter alia prayed for a degree of recovery of harsh possession of the suit premises, stating the cause of action to have arisen on the 1st day of June 2013 within the jurisdiction of this court. The defendant contested the suit by filing written statement, and in the written statement, defendant denied all the material allegation made in the plaint and has stated that this court does not have any jurisdiction to entertain this suit, and that the suit is not maintainable, and that the suit is bad for non-joinder and misjoinder of necessary parties, and that the suit is barred by law of limitation, and it is also barred by principle of estoppel and acquiescence, and there is no cause of action to file the instant suit. It is the positive averment of the defendant that the defendant was inducted as a tenant by the landlord Ashok Baid, Hira Kumari Baid, and Sudha Baid in respect of the suit flat at a monthly rental of rupees 3,000, including maintenance charges of rupees 900. that one of the landlords, namely Hira Kumari Baid, died, and after her death, the defendant became the tenant under Ashok Baid and Shudha Baid. Is further admission of the defendant that the erstwhile landlord filed case being number 21 of 1978 against the defendant for recovery of arrears of rent in Small Causes Court, Calcutta, and the said proceeding was compromised, and as per the compromise, the rent was reduced to rupees 2475, including maintenance charges, lighting of the common passage, staircase, and all services. That the defendant paid the said amount to the landlord up to May 1982, and thereafter the defendant came to know that the defendant did not pay the corporation tax, service tax to the owner association. The defendant has alleged that the association has threatened the defendant for disconnection of essential services, that the defendant filed a title suit being number 1639 of 1982 against the erstwhile landlord, that the defendant had preferred FMA number 1001 of 1982 against the order dated 14/10/1982 and order dated 23/8/1983, and the Honorable Court via order dated 2/2/1989 directed the defendant to pay to the owners association the actual liability of the owner and the balance amount of rent in the City Civil Court, Calcutta. That in terms of the said order, the defendant started to pay corporation tax and maintenance charges to the owners association and rupees 819 in the suit to the credit of the erstwhile landlord, and subsequently the same was decreed ex parte by order dated 17/4/2007 filed by the learned 6th bench, City Civil Court, Calcutta, and vide such order. It was declared that the defendant were liable to pay the maintenance charges of the suit properties and to provide for facilities of the plaintiff through pro forma defendant. It is the further case of the defendant that subsequently Shudha Baid, claiming herself to be the sole owner of the premises on the basis of the deed of conveyance dated 22/2/2001, claimed against the defendant praying for a degree for recovery of cash possession and other relief. That during pendency of the said suit, Shudha Baid informed defendant that she sold the suit flat to the present plaintiff, and that the defendant with a letter dated 1/10/2012 informed the present plaintiff that he was paying the maintenance charges of the building to the association as per order of the Honorable High Court, and if the plaintiff was agreeable to take the responsibility of paying maintenance charges to the association, defendant was ready to pay the total rent to the present plaintiff. Is further averment of the defendant that the plaintiff via its letter dated 11/10/2012 invited the defendant to take inspection of the sale deed, that subsequently Shudha Baid withdrew the suit being number CS number 1 of 2004 from the Honorable High Court. Defendant admitted that the defendant received a notice of ejectment dated 22/4/2013, and after receipt of the said notice, the defendant tendered rent to the plaintiff by money order dated 5/6/2013, and after refusal by the plaintiff to receive the money order, defendant started to deposit the rent with effect. Deposit the rent with the Office of the Learned Rent Controller, Calcutta, on and from May 2013 till August 2013, and that after appearing in the suit, the defendant filed an application under Section 7(1) and 7(2) of the West Bengal Premises Tenancy Act and had been depositing rent regularly before this court. The defendant has denied that the plaintiff is the owner of the suit premises, and the defendant has further denied that the premises was let out for residential purpose. The defendant has specifically stated that in the agreement of tenancy dated 15/5/1976, which was specifically mentioned that the flat would be used for residential cum clinic purpose. Defendant has specifically stated that defendant deposited the rent in the name of Shudha Baid till April 2013, and after withdrawal of the suit, the defendant started depositing rent in the name of the plaintiff at the Office of the Learned Rent Controller, Kolkata, from May 2013. Defendant has denied that the plaintiff reasonably requires the suit premises for his own use and occupation, and has denied that the plaintiff does not have any reasonable and suitable accommodation, and has further denied that there are 9 staffs or employees under the plaintiff organization. The defendant has further denied that there are leave and license agreement between the plaintiff and other licensors, and that the leave and license agreement are manufactured for the purpose of this suit. The defendant has denied that the residential accommodation is required to accommodate the manager and the assistant manager of the plaintiff company, and has further stated that the defendant, Mrs. SN Alloys Private Limited, are involved in real estate business, and Arun Sancheti is one of the plaintiffs, and he is also the director of many other private limited companies, and that Arun Sancheti has a big office being room number 503A on the 5th floor at Shantiniketan building, at 8 Kamak Street, and that Arun Sancheti is owner of 10B, 10C, 10D at Nilkant building, and flat number 10B and 10C are in the name of Arun Sancheti, and flat number 10D is in the name of Mrs. Sancheti Products. Defendant has further stated that the defendant has not done any act in violation of clauses MOP of section 108 of the Transfer of Property Act, and the defendant is not guilty of any waste and negligence, and the defendant has thereafter prayed for dismissal of the suit with cost. On the pleadings of the parties, the following issues were framed. But I'm omitting, Lord, kindly come to the next page. Issue number 4. Is the defendant defaulted in payment of the rent since November 2011? Is the suit premises reasonably required for own use and occupation of the plaintiff and for the use and occupation of the persons for whose benefit the premises is held? Then, Lord, is the plaintiff or any such person in possession of any alternate suitable accommodation within the area of Kolkata Municipal Corporation or in any area within 10 kilometers from the suit premises where the West Bengal Premises Tenancy Act 1997 extends? Now, Lord, kindly, Lord, then come to, Lord, the documents relied on by the parties, because other issues are not very relevant for our purpose.
What is the area of the suit room? 1600.
1600 something.
1600.
Plus, according to them, there is a terrace of 300. Open terrace of 300.
Open terrace, that is in the ground.
Yes.
In the ground. And it is
First floor.
First floor flat.
Yes.
That is the suit premises.
Yes.
About 1600.
Lord.
Comprising how many rooms?
Lord,
Not 1606 square feet
uh,
and then 300 square feet at terrace situated at and comprised in the municipal.
no,
premises.
how many rooms?
How many rooms, Lord, that would come up in the
So it is it was used for residential purpose.
Yes, residential, and Lord, a part of it is, Lord, for a speech therapy
Now
center, which was, Lord,
plaintiff requires it for residential purpose of the officers.
yes, residence for the office
Of the officers and managers.
Yes, manager and assistant manager. That is their
But
requirement.
you see, this present plaintiff took over when? Prior to how many years before filing the suit?
Look, they purchased in 2012 and filed the suit in 2013 almost. Or
Just
they
after 1
purchased in 2011 and filed it on 2013. So,
Okay, 2011 and 2013. That is the flat.
that is the flat.
You see, the entire building
Lordship.
comprises of different flats.
Different flats. It is a huge
So it
building.
is only one flat. The company is seeking, that is the suit premises,
Lordship.
to accommodate the managers.
Lordship. And we have shown and we have stated that in that building, the plaintiff has other flats where commission took place. I'll come one by one to that.
the entire property.
So,
not mine.
No.
The entire building is not yours.
Not yours.
Actually, you are
There are
seeking
4 flats.
one flat
One flat.
of the total of the building for accommodating your manager.
Yes, Lord. And
That is the
that's
purpose.
only flat that not only flat, but that flat belongs to me. There's no dispute.
No, you purchased the flat from the erstwhile owner
Yes,
and landlord.
Yes,
Now you want that flat
To
to
be
accommodate
used by
your
us.
manager.
Yes.
So that is
Used
how we
by
have
us.
established.
My lord. Used by us. In
Yes,
good
used by
form.
or your staff, whatever it is.
Yes. By my people. That's it.
Lord, that is, Lord, we are concerned about flat number 1A at Nilkant building, 8 Kamak Street. That is, Lord, the subject flat. Your Lordship will come across, Lord, other flat numbers which we have stated in our, Lord, the defense, that which, Lord, Arun Sancheti owns in that particular building, which will be very
Area.
germane.
Oh, there are other flats of the
Other
plaintiff
flats are also
in that building.
in that building, which is owned by, Lord, the other companies where, Lord, Arun Sancheti is a director. So that is, Lord, one of the points that we have raised, and your Lordship will come across, Lord, there was a commission. I'll come one by one. About, Lord, the question about the reasonable requirement and the bona fide of the reasonable requirement. So, my lord, so far as the plaintiff SN Alloy is concerned, they had purchased the property, filed a suit against my client to accommodate, my lord, the manager and the assistant manager. Suit property is 1A of Nilkant building, 8 Kamak Street. Now, my lord, your lordship has seen, my lord, in the defense that I just read out, my lord, we have taken a point that the Arun Sancheti is a common director of, my lord, the other companies which own the flat 10A, 10B and 10D.
Of that building.
10B, 10C and 10D of that property, of that building, I mean to say, the multi-story
No,
building.
but you see, in that building, in that flats, you see, other company managers cannot be accommodated. Suppose you are a director of X company.
Yes.
Okay, and you want to accommodate your manager of the X company.
Yes.
In a particular flat. Just because you are a director of Y company, it may not be possible for you to accommodate the manager of that company also.
True, but
It may not be. It is company's reasonable requirement. This company.
It is, but my lord, what I am trying to show before your lordship by lifting the corporate veil.
Yes, yes.
Now, my lord, your lordship will see that one person is, my lord, is in helm of affairs of the other companies. And my lord, that what he is now pretending here as a, my lord, a reasonable requirement may not
That
be
was there for that was there by way of commission. Is there any other flat, any premises owned and possessed in the name of this company, the plaintiff company?
No.
But some other
companies where, my lord, Arun Sancheti is a director. Therefore, the Arun Sancheti as a director, he is in control of, my lord, many companies there. And he has, my lord, other properties nearby as well as in that particular Nilkant building.
So have you ascertained whether the managers working here are also rendering their services there?
That will come out in the evidence, and my lord, I'll show the evidence one by one. Because that will be, my lord, necessary for addressing the first substantial question of law. Now, my lord, I was at page, my lord, yes, my lord, page 11.
Yes.
My lord, the documents relied by the parties. My lord, page 11 about, my lord, fourth line from, my lord, button.
Yes, last line.
Lordship. Therefore, my lord, exhibit 1 is the deed of conveyance dated 2011.
I'll just come back to it.
1811-2011. Thereafter, my lord, these are, my lord, not very important because these are, my lord, the information slip in respect of the suits which are pending against the erstwhile landlord owner. Then number 4 is, my lord, the Aadhaar card of myself, my daughter, my wife. Then, my lord, comes the letter of atonement, item number 6. Then, my lord, kindly come to item number 9. I am filing the photocopy of the agreement dated 15/5/1976, which has been marked as Exhibit 9, as the original is with the defendant and defendant did not produce the same in spite of receipt of the notice to produce the same. This is, my lord, the agreement by which my client had entered into the property, and this was, my lord, with the Bites, the original owner. Then, my lord, kindly come to, my lord, item number 15.
You are in possession of the suit property from which year?
1976.
1975?
6. That is the date of agreement, my lord. May 1976.
Yes.
Item number 15, these are the copies of the appointment letter of the executive of the company which have been marked as Exhibit 15, 2 letters collectively. Important. This establishes their bona fide of the requirement. I will refer to this because these are the material exhibit, my lord, on which, my lord, the reasonable requirement has been established before the appeal court. Then, my lord, item number 16. These are the leave and license agreement between the plaintiff and the licensors to provide residential accommodation to the employees of the company which have been marked as exhibit 16. 4 lease agreement collectively. Then 17, these are the rent receipt of the license fee which have been marked as exhibit 17, 8 pages collectively with objection. Then 18, these are the rent receipts of license fee for the period June 2013 to December 2015, which have been marked as exhibit 18 with objection collectively. Then 19, these are the salary slips of my employees which has been marked as exhibit 19 collectively with objection. This is the notice of eviction dated such and such which has been marked as exhibit 20. Then lot 22 is, this is the downloaded copy of the name of directors in respect of Sancheti Projects Private Limited, which has been marked as exhibit 21. Then 23, this is the gas connection booklet, which has been marked as exhibit 22. Then Lord, the commissioner's report, 25. This is also very important. Thereafter, Lord, the documents by the defendant. Lord, the challans have been marked.
So up to 25 is the plaintiff's documents.
Lordship.
Yes.
Lordship.
Next is
Then,
by
Lord, the defendant's, my client's document, of which, Lord, item number 5, the director details which have been marked as exhibit E with objection. 4, 5, Lord, these are concerning, Lord, the company master data and, Lord, the directors. Then, Lord, comes a certified copy of the deed of conveyance, which is dated 8th of May 2014, which has been marked as exhibit F with objection. This is at page 247 to 314. Then, Lord, comes the details of the director of the plaintiff company, which has been marked as exhibit H with objection. Then, Lord, the deed of conveyance dated 7th May 2014, which has been marked as exhibit 1 with objection. Then, Lord, the rent control challenge, Lord, I am not concerned about that. 11 is, Lord, the net copy of the Ministry of Corporate Affairs, which have been marked as K, K1, K2, K3. Because why I say the challans are not important, because it was not decreed on the ground of, Lord, the default. Now, Lord, the evidence adduced by the parties. To prove its case, the plaintiff has adduced evidence of one Arun Kumar Sancheti, one of the directors of the plaintiff as PW1, and Advocate Commissioner Tinia Das as PW2. The documents filed on behalf of the plaintiffs have been marked as Exhibit 1 to Exhibit 24 by 1. PW1, Arun Kumar Sancheti examined himself as PW1, and in his examination in chief, he corroborated the plaintiff case, and in his cross-examination, he stated that the names of the other directors of the plaintiff company are Sunita Sancheti, Sampadmal Sancheti, and that Sunita Sancheti is his wife, and Sampadmal Sancheti is his uncle. He further stated that the shareholders of the plaintiff company are the members of his family and his uncle's family and others. But this is very important. He further stated that 7 or 8 private limited companies have their registered office at 8 Kamak Street, and he further stated that there are 3 or 4 companies where he or any member of his family are directors. He admitted that he is the director of Sancheti Enclave Private Limited, but he failed to state the name of other companies where he or any of the members of his family are directors. He admitted that the office accommodation of the plaintiff company at 8 Kamak Street was not inspected by the commissioner. But kindly mark this. He stated that the plaintiff company is involved in the business of finance and broking.
Okay, that is, he stated the plaintiff, right?
That is, his evidence is being scanned by the trial court. He says that he has offices, but it was not inspected. But I can show before your lordship the other flats, which are owned by other companies, which he says that also he is a director. Those were inspected. and corroborated by the PW2, that Tinia Das, who is the Advocate Commissioner.
Yes.
He stated that the plaintiff company is involved in the business of finance and broking, and still he further admitted that as per the memorandum of the plaintiff company, the object of the plaintiff company is to promote and develop properties. He stated that he is not aware of the existence of Mrs. Sancheti Estate Private Limited. He further stated that Sancheti Project Private Limited is running to project at Rajarhat. He admitted that he is one of the directors of Mohabaleshwar Distributor, and he is one of the directors of Sancheti High Rise Private Limited, and he is one of the directors of Ankita Housing Private Limited. He failed to recollect if he is a director of Charnock Estate Private Limited. He failed to say if all those companies have their registered office at 8 Kamak Street or not. He stated that the plaintiff company purchased the suit property from Sudha Baid and stated that Mrs. Rosewood Merchant Private Limited was the confirming party in the deed of conveyance. Exhibit 1. He further stated that the registered office of Mrs. Rosewood Merchant Private Limited is at 8 Kamak Street. He stated that he is not aware if the office of Mrs. Rosewood Merchant Private Limited is running analogously from the office of the plaintiff. He further stated that consideration amount was paid to Sudha Baid and the confirming party. In his further cross-examination, he stated that the suit has been filed on the ground of reasonable requirement of the plaintiff. He stated in his cross-examination that he has stated in the plaint that the plaintiff requests the suit premises to accommodate Nobin Kumar Sethia and Arun Kumar Baid, two employees of the plaintiff company. And he further stated that he has filed the appointment letters of these two employees, and Prakash Sharma, who is the authorized signatory of the plaintiff company, has signed on the appointment letter. He further admitted that Prakash Sharma has signed as director of the confirming party, and that is Mrs. Rosewood Merchant Private Limited. And Prakash Sharma issued money receipt. This is, my lord, where the exactly, my lord, where I'll show before your lordship, my lord, that how, my lord, it is intertwined about, my lord, the bona fide of the requirement. That Prakash Sharma is, my lord, the authorized signatory of the plaintiff company. He was also, my lord, he issued, my lord, the money receipt in respect of that, my lord, Rosewood Merchant Private Limited, who is a confirming party in the sale deed of, my lord, the plaintiff. He further stated that Navin Setia has signed as the constituted attorney of the vendor, Sudha Baid, and Navin Setia accepted the consideration amount on behalf of Sudha Baid, and he admitted that Navin Setia is the same person who had signed as the constituted attorney on the deed of conveyance, and for whose accommodation the plaintiff has filed the instant suit. The Sudha Baid's constituted attorney is not a person, Navin Setia, for whose requirement, my lord, they are asking for, my lord, this particular property, my lord, to be, they want to accommodate Navin Setia in the property. So the nexus, which goes to the root about the bona fide. But I will explain that, my lord, with reference to the evidence. But just to give your lordship, my lord, an overview of the matter, that why I am saying that, my lord, it is not a bona fide requirement, but it was, my lord, instrumentalized, organized, my lord, in a very meticulous manner. Maybe Mr. Basu was instrumental at that point of time.
Yes.
In his further cross-examination, he stated that he and his father are the owners of flat number 10B and 10C.
Yes, it
Nilkant
is
building.
further. That is which paragraph?
Milord, 12. I'm sorry. Milord, page 17, 12. In his further cross-examination, he stated that he and his father are the owners of flat number 10B and 10C, Nilkant building, and he further stated that he does not know who is the owner of flat number 10D, Nilkant building. These three flats have been inspected. An inspection report is on record.
Flat 10B, 10C and 10D.
Lordship.
And 10A is the suit property.
1A. 1A is the suit property.
So 10A, 10B and 10C, 10B, 10C
Lordship.
and 10D, this commission was done.
Commission was done. PW2
in the same building.
In the same building.
Okay.
Nilkant building.
Where this present director of the plaintiff has admitted that they are that he and his father are the
Lordship.
Are joint owners.
Joint owners. And the commonality between them has been proved by my client by bringing forth the company data to show them as the directors.
No, you see, properties may be owned by some other company where this particular person is a director. But here, you see, this two flat, it is in the name, not in the name, not of the company, but of this individual. This is the thing.
No, in name of not the company.
No, this 10B and 10C.
They are standing in the name of Sanchiti Projects.
No, they were. You see, he and his father are owners of flat 10B and 10C.
That is in the personal name. And 10D is standing in the name of Sanchiti Projects, which Mr. Arun Sanchiti says that he is one of the directors.
These two flats are in his name and his father's
Lordship. 10B, 10C are in the family, and Sanchiti Project owns 10D. He admitted that flat number 10D was owned by Mrs. Sanchiti Private Limited, and during the pendency of the suit, the said flat has been sold to Binay Kumar Baid. And he admitted that he is one of the directors of Sanchiti Projects Private Limited.
So 10D.
Yes, 10D. He admitted that in the tenancy agreement, Exhibit 9.
This sale took place prior to the suit?
Sale took place prior to the suit.
Prior to the suit.
Prior to the suit. No, it
Yes.
But I'll clarify on this query, but I've asked him to check it up.
Whatever it is, whether it has come from your cross-examination or not regarding that sale.
Yes. He admitted that in the tenancy agreement Exhibit 9, it has been mentioned that the purpose of tenancy was for residential as well as for the purpose of doctor's clinic. He denied the suggestion that the plaintiff company was in possession of 3 flats being flat number 10B, 10C, 10D at Nilkant building at the time of filing of the suit. He failed to say if Sancheti Projects Private Limited and plaintiff company have common directors. He denied the suggestion that he is the exclusive owner of Sancheti Projects Private Limited. He admitted that Sancheti Projects Private Limited was the owner of flat number 10D Nilkant building. PW2.
He denied the suggestion that he is the exclusive owner, but he admitted that he is the director.
Gotcha. Tinia Das, learned advocate commissioner, examined herself as PW2, and she stated in her examination in chief that she is the practicing advocate of this court and that after receiving the writ of this court, she had issued notices to both the parties and thereafter conducted inspection of the suit premises in the presence of both the parties. And subsequently, she filed report. In her cross-examination, she stated that she was directed to inspect flat number 10B and 10C at premises number 26 by B, Kamak Street, PS Shakespeare, Sharoni, and she admitted that she inspected those rooms which are shown to her by the defendant. On the other hand, the defendant has adduced evidence of one Chandralekha Anandsayo, the wife and constituted attorney of the defendant, as DW1, and the documents filed on behalf of the defendant has been marked as Exhibit A to J. DW1 in her examination in chief corroborated the written statement, and in her cross-examination she stated that her husband used to supervise the suit which was filed before the Honorable High Court. She admitted that Mr. Texan Sayo is in Kolkata, and she further admitted that her husband, Mr. Texan Sayo, is a doctor by profession and is still in practice, and that Mr. Texan Sayo conducts his chamber from the suit premises. She denied the suggestion that her husband is physically fit. She further admitted that Sudha Baid was the original landlady and that Sudha Baid wrote a letter informing that she had sold the property to SN Alloys Private Limited, and she further stated that she had deposited rent at the office of the rent controller in the name of the present plaintiff. She further admitted that SN Alloys and Sancheti Projects Private Limited are different companies, and flat number 10D stood in the name of Sancheti Projects Private Limited. In a further cross-examination, DW1 stated that the residential address of Naveen Sethia has been mentioned as 8 Kamak Street, Shanti Niketan Building, 5th floor, room number 3A. And she admitted that she cannot say if Shanti Niketan Building is used entirely for commercial purpose. And she admitted that the residential address and office address of Mr. Sethia is same as 8 Kamak Street. Argument forwarded by the parties. May I just take your lordship, to the findings so far as the default is concerned, which is at page 24, paragraph 26. The court said that I am not a defaulter in payment of rent because there was a deposit. Then the change of user also at page 25. There is no change of user because it was in the agreement that I can use it for my the clinic purpose. So waste and negligence was also not decided against my client. Then comes reasonable requirement at page 26, paragraph 29.
Yes.
The plaintiff has alleged in the plaint that the plaintiff reasonably requires the suit premises for its own use and occupation. The plaintiff has alleged that it requires the suit premises to accommodate its managers, assistant managers. It is pertinent to mention here that the plaintiff has not stated in the plaint as to for whom the suit premises is required. The plaintiff has pleaded that the plaintiff has taken rented accommodation of 11-month leave and license, but the plaintiff is curiously silent as to who are the manager or assistant manager accommodated in the rented accommodation. The plaintiff has tried to improve upon its case of reasonable requirement by giving two names in affidavit evidence. One is Naveen Kumar Sethia, alleged manager, and Arun Baid, alleged assistant manager. Similar, the first point is that they are giving evidence which are not borne out by the pleadings concerning the reasonable requirement and naming the officers they want to accommodate.
No, it has come out where? In cross-examination?
Only in the affidavit evidence. Second line of page
Naveen
30.
Shettia.
Yes. Not in the plaint, according to the learned trial court. Flat number.
Yes, there is a. Anyway, you.
I'll just complete the plaint
because 3 p.m. there is a fixed.
I know,
Anyway.
I'm just that's the reason I'm rushing, just to complete the trial court. Because the trial courts, I can place the appeal court on the next day and converge on the points of law that I want.
Then the court will consider whether any new ground can be formulated or not.
That your lordship can at any point of time.
Yes.
Now, here another the plaintiff has filed two appointment letters dated 3/4/2000. Page 26, Lord, last line.
Yes.
The plaintiff has filed 2 appointment letters. Page 26.
Yes.
Dated 3/4/2012 and 1/4/2013. But kindly mark the date because I'll relate this with the purchase and Lord, the proximity, which goes to the root about the bona fide.
Yes.
Both signed by one Om Prakash Sharma. In both the appointment letters, the salary amount is written with rent-free accommodation, but the terms and conditions filed with the appointment letter is silent about providing accommodation to the said persons. At the outset, it is submitted that the so-called manager Naveen Kumar Setia and the assistant manager Arun Kumar Boyd do not come to give evidence. And to corroborate the alleged requirement, the agreements of leave and license produced before the learned court does not show the same are executed for the alleged manager and assistant manager. No document is produced to prove that the said manager and assistant manager are residing at the premises alleged to have been taken for them. No document has been produced before the learned court to prove that they are still in the employment of the plaintiff. The said ground of reasonable requirement is baseless and concocted. Now, the deed of conveyance is produced before this learned court. The story of the defendant is pathetic. The landlords have been trying to evict the defendant since 1978. It has been categorically stated in the written statement that the erstwhile landlords initially started a distress case number 21 of 1978 against the defendant. The defendant was constrained to file title suit number such and such against the erstwhile landlord, which was decreed by the City Civil Court at Calcutta. Lastly, the vendor of the plaintiff filed CS number 1 of 2004 against the defendant in the Honorable High Court at Calcutta for recovery of harsh possession. The said suit was withdrawn on 10/4/2013 and March after the execution of the alleged deed of conveyance. The defendant further stated that the deed of conveyance by virtue of which the ownership is claimed is sham and colorable one. On a close look to the deed of conveyance executed on 18/11/2011, it will show that the vendor, Shudha Boyd, is represented by a constituted attorney, Mr. Naveen Setia, the alleged manager of the plaintiff. The confirming party is represented by its director, Mr. Prakash Sharma, the appointing authority of the alleged manager and assistant manager in the appointment letters. And the plaintiff purchaser is represented by Mr. Arun Kumar Sancheti, the director. So all the persons, the vendor, the plaintiff, purchaser, and the confirming party are represented by persons belonging to the plaintiff purchaser. This shows that the deed of conveyance has been manufactured, concocted by the plaintiff purchaser and the vendor in collusion with each other to evict the defendant. The plaintiff filed an application for holding local inspection. The plaintiff got 2 flats, number 10B and 10C, at such and such inspected. Both the flats are in possession of Arun Kumar Sancheti, the director of the plaintiff. He has claimed himself to be the owner of the said flats. The defendant in his written statement stated that Arun Kumar Sancheti is also in possession of flat number 10D at the said premises. The plaintiff stated that the said flat belongs to Mrs. Sancheti Project Private Limited. The plaintiff did not allow commission to be held at the said flat. In cross-examination, it has revealed that the said flat is sold during the pendency of the suit. Mr. Arun Kumar Sancheti is the director of the plaintiff, as well as Mrs. Sancheti Projects Private Limited. In the cross-examination, it has also been revealed that Mr. Arun Kumar Sancheti is director of many private limited companies, that the flat 10D was sold by Arun Sancheti as director of Mrs. Sancheti Projects Private Limited on 7/5/2015. VDR registered sale deed. The sale of the flat number 10D.
So the suit is in 2014.
The suit file is 13 or 14? 13.
The sale is in 2015.
No, the sale was in, according to them,
Yes,
it was
that-
executed in 2011.
Sancheti, Arun Sancheti.
Arun Sancheti is, I mean, this company.
Yes.
I mean, SN Alloys had purchased.
SN Alloys.
Alloys. SN Alloys is not the company who had, who is the plaintiff and the purchaser of not this particular 1A flat.
Yes. No,
SN
no,
Alloys.
no, this last line.
No,
10D.
that is in respect of flat number 10D, the other property. Has no reasonable requirement. Plaintiff, although has stated that it has office at 8 Kamak Street, and alleged manager Mr. Navin Setia had mentioned his residential address at 8 Kamak Street, but no attempt was made by the plaintiff to show its accommodation at 8 Kamak Street. The plaintiff has nowhere stated in the plaint about flat number 10B and 10C. The plaintiff is not the owner of the said flats. Then why the said flats were inspected? The plaintiff is a private limited company where Mr. Arun Kumar Sancheti and his family members are promoter directors and also shareholders. The other companies, as mentioned in the written statement and as admitted by the PW1 in cross-examination, are all private limited companies. These companies are managed and controlled by Mr. Arun Kumar Sancheti and his family members. It has been admitted by the PW1 that the said private limited companies are mostly engaged in construction business. They are constructing flats and offices and selling the same. The question with regard to the construction undertaken by the plaintiff are avoided by PW1. It is most respectfully submitted that during the last few years, the PW1 through his private limited companies have constructed and sold flats and offices. But the instant suit has been filed on concocted ground of reasonable requirement. The ground of reasonable requirement is not genuine, sincere, and honest. The plaintiff has failed to prove the ground of reasonable requirement. The plaintiff defendant submit that the suit is liable to be dismissed with cost. And thereafter, my lord, the statement by the plaintiff has been, lord, that is, lord, has been recorded there. Lord, your lordship will kindly come to, lord, page 47, issue number 5 and 6.
Yes.
But this is not the decision of the trial court on the issue of reasonable requirement.
Yes. It is held against the plaintiffs.
It is held against the plaintiff. The case was not proved. The court did not believe because of the reason, Lord, that our submission was such and such, as well as, Lord, by going into the evidence and scanning the evidences. That your lordship will find, Lord, the entire, Lord, this is up to page 54, Lord, about 5th line from top.
Yes, yes, it is considered in details.
Lordship. So, Lord, if your lordship, Lord, allows me, I can place it on the next day, or even today, if your lordship allow me to
We will place it on the next day.
Very well.
Yes, recorder.
Your lordship is inquiring about the composition of the flat, the number of flats, number of rooms in the flat. It's 3 rooms with 3 attached toilets, a huge drawing room, a separate dining room, and 1 balcony, 2 balconies, and 1 open terrace. This is the composition of the flat.
1600.
1600 plus 300 open terrace in front of the flat.
Okay.
Attached to the flat.
First floor.
First floor.
Learned.
এটা কোথা থেকে পেলি মানে is it something there on record?
All the parties are present. Mr. Mukherjee submits on behalf of the appellant but could not conclude the submissions. Let this matter appear on. I'm keeping it in the month of January because next 2 weeks this bench will not sit.
If my lord pleases to fix any date and time, my lord.
Yes, it's January, month of January.
Continue to do
আমার আরো হয়তো 2 দিন লাগবে।
Lordship will kindly keeps it 1 more day for Mr. Mukherjee to submit. Otherwise, the continuity will get.
No, no.
No, no. আরে পেজ বসবেন না জলপাইগুড়ি।
So next 2 weeks this bench will not sit. So anyway, I'm keeping it in the month of January. আচ্ছা জানুয়ারি থেকে 7 তারিখে দেখুন তো 7 বা 8 হ্যাঁ সকালবেলা যেটা টাইম হলো
আবার সে করতে
তোরা বলে দেখ
সকালবেলা
be able to accommodate us this week, for Mr. Mukherjee to submit and
because
finish
you see it is very difficult.
It will be difficult because January will a long gap.
Because you see, I'll not be able to conclude also because had I been able to conclude, I could have.
Apply in January, my lord, if your lordship permits Mr. Mukherjee to
Because no purpose will be served. You see again, Because I have to keep it after 3. I don't know.
On the 9th, my lord, and first week it will be almost a month. So that is the only apprehension.
জানুয়ারি আচ্ছা এমনি 7-8-এ কি আছে ফিক্স আছে কি না ওই দুটো কি 3টের সময় না না সেকেন্ড হাফটে বলছি সেকেন্ড হাফে 7 বা 8 তারিখে 7 তারিখে আচ্ছা আচ্ছা এই সপ্তাহে ওই বৃহস্পতিবারে ফাঁকা
Malad, on the last occasion, it was my endeavor to demonstrate before your lordship that the defendant number 1 group in their affidavit has accepted the fact of there being lots And that there also, my lord, if your lordship kindly takes the affidavit in opposition of Srimati Ranjana Barik, dated 3rd of July 2025. I'd not like to repeat, my lord, I'll just.
Affidavit in opposition to GA 23.
Of GA 23, yes.
Which is taken up for consideration.
Yes, yes.
And in this application, you have sought for a declaration with regard to the shares as per the terms agreed between the parties.
I have sought for a preliminary decree.
That is a declaration.
Yes.
In terms of the agreement of between the parties.
I'm obliged.
By lots.
My submission is, my lord, the parties have agreed to the lots way back since 2004, which is evident from the minutes. Mr. Dotto is also supporting my submission with one condition, that Mr. Dotto's client is wanting that there is no dispute with regard to their lot.
They be released and
They be
declared.
released.
And
They be
their
released.
shares be declared.
They're accepting the fact of lots, or else, my lord, they could not have wanted a release. What they are saying is that Lot A and Lot B, you're disputing, you're fighting amongst yourselves.
So far, Mr. Dotto is concerned, there is no dispute. So whether the court is empowered to release Mr. Dotto by declaration, by whether, first of all, whether the suit can be decreed in part or not.
Yes,
by releasing Mr. Dotto. That is one.
I said that the properties of the parties have been mutually divided.
That
between
is your
two lots.
stand. And assuming if it is not accepted, at least your lot is free and undisputed. So you want to be released and your lot be declared.
The scope of this application is very limited between the two groups over a certain particular point.
That is, yes. If
So
Mr.
that
Ghosh's,
is sorted out.
if Mr. Ghosh's application is considered, there are two remedies, you see.
Yes.
One is to accept what Mr. Ghosh submits, and assuming if it is rejected on reasons, with reasons, so whether you can be released by declaration, necessary declaration. That is the second
That is the
alternative.
prayer of Mr. Dotto, my lord.
Yes.
Whether Mr. Dotto's client can be released or not, I'll make my submissions on that. My lord, let me first deal with
Decreed in part, by declaring the suit in part.
My lord, may I meet the
Yes,
argument
now-
made by Mr. Rupa Ghosh first?
Now this is Ranjana Badik's affidavit in opposition.
My lord, Ranjana Barik's affidavit in opposition, your lordship, I have shown this on the last occasion, my lord, at the cost of repetition. May I just show the relevant portion once again? Paragraph 11, page 12. It cannot happen. It cannot happen.
Yes, which paragraph?
Yes, my lord. Paragraph 11, my lord, page 12 of that affidavit. The last line, my lord.
Yes. Paragraph 12.
Paragraph 11, page 12.
Paragraph 11, page 12.
Last line, your lordship kindly comes.
Yes.
I further state and submit
Yes.
that I am not opposed to accept the proposed Lot A, but if parties are interested to settle the disputes full and finally, then in such circumstances, all the properties must be properly and fairly valued by a valuer appointed by this honorable court.
Conditional acceptance.
Yes, my lord. So this line has two sections, as has very rightly fallen from my lord. First, my lord, they're accepting the fact that there is a Lot A.
Yes.
So, my lord, acceptance of lot may automatically and impliedly shows that there has been an acceptance with regard to Lot B and Lot C. Automatic. It cannot be that Lot A has been made in isolation without there being two other lots, because there are three different groups, each accepting one lot. So the acceptance of the making of lots come out from the first portion of the sentence, submission. Now, my lord, the second as to whether this conditional acceptance can at all at this stage be accepted by my lord or not, with regard to the properties being valued. For that, my lord,
Now, even if it is accepted, whether it is accepted subject to valuation or not.
whether at all that valuation can be reopened, I'll tell your lordship what has happened.
Why, whether it will be reopened or not.
Yes, at this stage, your lordship will kindly bear in mind, with deepest of respect, I make this submission, that this suit is a 60-year-old suit. Many things have happened between the parties when the parties have tried their best to settle the dispute once for all. And my lord, I've also shown it on the last occasion that there have been several orders passed by this honorable court, repeatedly reminding the parties and wanting the parties to come to a final settlement.
And if your application is allowed, it will amount to a preliminary decree.
I'm obliged. That is exactly my prayer. Declaration of shares which the parties have already agreed amongst themselves. That is the reason why, my lord, these shares have been named as Lot A, Lot B, Lot C. I'm coming to that. It is only for the purpose of identifying as to who is going to get which properties that these lot system has been made and accepted.
Yes.
My lord, this is with regard to the first portion, acceptance of lot.
Which is usually followed when there are several properties of the co-sharers.
Yes, and there are a huge number of 108. Barik family, your lordship knows North Calcutta. We all know the Barik family. Huge properties are there, and they're all being wasted because of all this litigation and for trivial matters.
That is why this is a suit for partition and administration.
Yes, my lord, that whether your lordship is empowered to, my lord, consider this suit to be that
partition and administration
yes,
suit.
I'll satisfy your lordship with the
Then
law
that
provides
court
that.
assumes the power.
Absolutely.
If it is treated as a suit for partition
Yes,
and
my lord.
administration.
My lord, first of all, the conduct of the parties, and secondly, the law provides. I'll show the particular law. The law provides so. The nomenclature of a particular suit cannot quite determine as to whether the parties come to a final settlement or not. After all, the intention of the parties runs supreme. Parties for the last 60 years have been wanting to get a final solution to this problem.
Yes. So you have referred to the affidavit of the contesting respondent Ranjana Barik.
Yes, ma'am. Then, my lord, with regard to the possibility of any revaluation or not, your lordship will be pleased to come to the affidavit in reply of the same group, defendant number 1 group. My lord, that has been affirmed on 23rd of April 2025.
Ranjana Barik is under lot 1.
Yes, my lord. Now the affidavit.
Lot A.
Lot A, defendant number 1 group.
Defendant number 1 group.
Yes.
Lot A.
Yes, my lord. Now your lordship will be pleased to come to the affidavit in reply affirmed by my client on 23rd of April 2025. Chandranath Barik.
That is defendant number 2.
2 group. Yes, defendant number 2 group. My lord, they are all representatives of groups. 23rd of April 2020.
That is Chandan Barik.
Yes, my lord. Chandranath Barik.
So it is here 1A1 Chandan Barik. Oh, Chandranath Barik.
Chandranath. Yes, 2H. Right. My lord, that revaluation will not be possible at this stage, will appear from pages 22 onwards. Page 22, your lordship will kindly come, my lord. That's an extract of the examination in chief of Shambhunath Barik, the predecessor in interest of group 1, defendant number 1 group. Lot A, group, defendant number 1. Lordship has got, my lord, page 22. Yes. May I just read out a few questions and answers? Question 1440. Is there any property at Darjeeling lying in your name? Answer is yes. The estate Kalipada Barik purchased a house in my name. So, my lord, the father of the defendant numbers 1 group is admitting the fact that a Darjeeling property was bought in his name by the estate. Then, my lord, when was it purchased? Around 1940.
Yes.
Then, my lord, your lordship will please to turn over to the next page. I'll not trouble your lordship with the other relating to other property.
This
My
is
lord,
mutation,
yes,
representation.
my lord, your lordship will kindly see the date, 2016. To whom it is being addressed? Chairman, Darjeeling Municipality, Mutation Department, Darjeeling, West Bengal. And who is doing it?
The vendors.
Yes, my lord. The vendors are who? The defendant number 1 group only. Ranjana Barik, Sholil Barik, Shuna. They are only the defendant number 1 group. Defendant number 1 group. Your lordship will kindly see page 2, the first line.
Yes, page 2, first line.
First line. As aforesaid, Srimati Ranjana Barik and we, the undersigned, are the present joint owners. So, my lord, this Darjeeling property, which admittedly has been an estate, part of the estate of Kalipada Barik, which has fallen in Lot A way back in 2004. In 2016 is being admitted to be that of their own. Lot A.
This property was there in your resolution of the meeting.
Yes, I'll show that. I'll show that. That's in my petition. So, Darjeeling property, they are claiming to be their own and they have sold this property. Proceedings have been kept and retained by them only. So, I put a question to myself. Is it not by conduct and acceptance of the lot? 5 properties come in my lot. Property A, B, C, D, E. I sell out, I'm claiming property A to be my own, and I'm selling it off and retaining the proceeds for my own benefit. Had the
during pendency of the suit?
Yes, 2016. 2016. And now, my lord, that Darjeeling property had fallen under Lot A will appear from the petition. If your lordship kindly comes to the petition. Yes. And
Page
12, your lordship will kindly come. The lots have all been, the properties which are falling under which lot have all been set out.
Yes.
Page 12, Lot A.
Yes. Shambhunath Barik group.
Yes, my lord.
That is Ranjana Barik's group.
That is Ranjana Barik's group. Yes. So, my lord, all the properties are set out. Your lord.
Lot B is.
Yes.
Sarojendra Nath Barik.
Yes, my lord. May I just show that page 14 S, Darjeeling property, comes under Lot A.
Lot A. That is that
Yes.
groups.
So, my lord, from this, 2 things come out. Acceptance of the lot system and acting in terms of that acceptance by way of having, my lord, declaring in public that we are the owners, having sold and retained that particular proceeds for themselves only. Had they distributed the proceeds, then also there could have been a possibility of saying that no, there has not been any lot system, I'm not accepting it. But that has not been done. Since 2016 till 2025, proceeds have all been utilized by them. Now I put a question to myself. Can there be any question of any revaluation when a portion of the property has already been sold? What will happen to that particular property? Who is going to revalue that property? what would be the value of that property today and the value of the property at which it was sold. If it is much higher today, who is going to compensate for the difference? So these things will come out, and you cannot approbate and reprobate. Having had accepted, you cannot now turn around and say that I'm going to accept the lot only if properties are revalued. The question of blowing hot and blowing cold cannot come. And your lordship will kindly not permit that after 60 years. That is with regard to, my lord, the defendant number 1 group. Yes. I think one is disputing that. Similarly, my lord, with regard to the defendant number 3 group, one property which had fallen in their lot has also been sold by them. There is no dispute.
No, one is Ranjana Parik's lot.
They have sold.
The other is Mr. Datta's
yes,
lot.
they have also sold.
That is
So
also sold.
parties have
That is the lot
accepted-
B.
That is lot C.
Lot C.
That is lot C.
Right, lot C.
So, my lord.
And nobody is disputing the lot C.
No, no one is disputing either lot A or lot B or lot C.
No, lot A and lot B, the question of valuation comes only with regard to lot A and lot B. So far, lot C is concerned.
No. She is wanting valuation with regard to the entire estate. She is wanting that all the properties are to be valued now. It is as per her whims and fancies.
Now, the question of lot C being clear.
No, they are claiming that the lot C, there is no dispute. Let that be. I'm clear of that lot. I don't want to get into the hodgepodge of lot A and lot B. But what defendant number 1A group is wanting, my lord, I have shown that from that affidavit, that entire properties need to be revalued.
Entire suit property.
Entire suit property. That to settle the disputes full and finally, then in such circumstances, all the properties must be properly and fairly valued by a valuer appointed by this honorable court. She's doing it in July 2025. In 2016, she claims to be that her group is the owner. She sells the property. They retain the money. And now in 2025, she's wanting a revaluation. She's blowing hot and cold. She cannot approbate and reprobate, my lord. That is my humble submission with regard to this portion of revaluation. And my lord, admittedly, the other group has also sold. So both
is Mr. Datta's group.
Yes. So the groups have sold their properties which has fallen in their lots.
The basis that Mr. Datta's group be cleared from this dispute.
No, my lord,
Now,
that
what is
will
the
not,
basis?
I cannot support this contention of Mr. Datta. I cannot. My lord, I am very grateful to Mr. Datta's client that he is supporting the lot system having been
Supporting
established.
But
I'm in a
regarding his
precarious
release, what is
condition.
the basis?
I'm in a very precarious condition. They are supporting me with regard to one stand, and they are supporting me with regard to another stand. So, my lord, with regard to
Mr. Datta's client does not want any devaluation.
No.
Only release.
He is wanting to come out
So
of
that
this hodgepodge.
you and the other group do not stake any claim so far Mr. Datta's lot is concerned.
Exactly.
Both of you. That is Mr. Datta's claim.
Exactly. To that, my submission would be, my lord, that cannot be done. This lot system that was made to finally put an end to the dispute with regard to all
So
the
it cannot be
properties.
done in a piecemeal manner.
Cannot be done in a peaceful manner. And now the question of any piecemeal manner or the question of any revaluation does not arise, inasmuch as the parties have accepted and have been accepting it since 2004. I'll show that from the minutes annexed to the petition. The minutes are there.
Page.
Yes, my lord. I'll show.
Annexure.
Page 21 to the.
Yes, page A, annexure A.
Yes, my lord.
This is 2022.
No. I'll show, my lord. 2004 is in that, in my affidavit in reply. The one just I showed.
No, because you see, the
That's the
meeting was deferred for the purpose of certain inspection with regard to the back portion of that Chaya cinema.
All this has been done.
In 2004.
It's a given go by year. 2004, your lordship will kindly come to page 15.
2004. That is reply.
In the reply. I just showed that reply to your lordship, where, my lord, the
page
Page
Yes,
15.
this is, no, this is also 2000, page 15.
Yes, my lord, 1-5.
Yes, page 1-5.
Yes, of Chandranath Barik's reply.
No, Chandranath Barik's opposition. No, Chandranath Barik's, no, this is whose reply?
Chandranath Barik's reply.
Yes, Chandranath Barik's reply. Yes,
Yes.
your client's reply.
Yes.
That is page 15.
Yes, my lord.
Yes, 2004.
2004, your lordship sees lot system. First lot goes to Mr. Doctor's client. The following properties to be allowed to the group of Shochin Barik deceased. 3 properties go, out of which B has already been sold by them. Admittedly, there's no dispute.
So this is, okay, lot. Group B.
Yes.
Shochin Barik.
Defendant number 3 group.
Yes.
And the property which is against item number B, that is P20 Raja Basantharai Road, that property has also been sold. So similarly as that of lot A, this lot, the defendant number 3s have also accepted the lot system and have acted in terms of that distribution. They have sold 1 property each from their lot. So they have, my lord, not only accepted, but in terms of their conduct, they have also executed the acceptance. Your lordship will kindly see the rest in the next paragraph starts, the rest of the properties to be divided in 2 lots.
Well, that is
Page 15.
page 15, yes.
First, these 1, 2, 3, 4 properties go to Mr. Datta's client.
Yes.
Then, my lord, the rest of the properties to be divided into 2 lots.
Yes.
And 1 lot will consist of properties around Chaya Cinema, and the other lot will consist of properties around such and such. So the lot system have been done and accepted way back in 2004. So whatever was the system was all accepted and acted upon. But the most important, I'm putting a stress on the
Now you are insisting on the lot that is around Chaya Cinema.
Yes, that is my lot. It has fallen in my client's lot.
And the other is with regard to the
Dorpona Cinema and all that.
Cinema and Vivekananda Road.
Yes. I'm going to try cinema.
Then residential houses will be divided into?
That is the reason why I wanted, my lord, an appointment of commissioner in my prayer.
It's
Because
no, residential houses
yes
will be 2 equal.
Page 17 says half of the residential house at 194 Vivekananda Road, Calcutta, except portions allotted to Shochin Barik group and Thakur Dalan, etc. That will come to one particular group.
Yes, so Shochin Barik is excluded. So from this, with regard to the residential houses, of these 2 lots.
Shochin Barik's group, no, my lord. If you, with deepest of respect,
yes,
some portion has been allotted to Shochin Barik group and the Thakur Dalan with regard to the residential house.
Yes.
So apart from the portion which has been given to that group, the rest of the half portion will go to this group. So it is for this reason that my prayer B is appointment of a commissioner partition so that he can divide the residential house as per the lots which have been agreed upon.
Okay. Yes, property standing in the name of the person to be allotted to the, yes.
Okay, fine, very well. That means the commissioner will do it. Doesn't matter.
So that is.
So, my lord, the question of
rest of the property, yes, 2 lots.
What I'm trying to impress upon your lordship from this is, from 2004 itself, the lots have been agreed to by the parties, and thereafter, 2 of the groups out of the 3 have already acted upon in terms of the Yes, my lord, that is the thing that they've acted upon, they've accepted. Now they cannot turn around and say, I'm going to accept provided there's a revaluation. That is my submission. And my lord, from this also flows another point. The question of non-maintainability of the suit and my lord not being able to pass this preliminary decree also does not arise. They are stopped.
Whether the amendment that after amendment, what is the relief sought in your plaint?
My lord, with deepest of respect, even if that is so, if I say that to the extreme, if I go as per their argument that there's no relief, I put a question to myself. Can the parties not come to a settlement, put an end to this dispute?
Yes.
That is the only question your lordship will consider. And from the conduct of the parties,
Whether there is any admission.
Whether there's an admission, whether there's any action on the basis of that admission. Or more technical. My lord, a nomenclature, my lord, I put a question to myself, would a nomenclature hold natural justice being done from this honorable court? Parties are wanting to settle the dispute which is there since 60 years. The nomenclature of the suit is not there, so it cannot be given. My lord, that does not call for justice, my lord. And even if that cannot be done, the law provides, I'll show that, my lord. The law
This is
provides.
the last is the meeting, minutes of the meeting, page 20.
Yes, my lord, that is in the petition, the last one.
Yes, page 20. Let us see that also.
That, in my humble submission, will not hold much water inasmuch as by 2016 they have accepted the lots and they have sold. This is of 22. They have already done it prior to
Whatever are
that.
the facts, you see, nobody can improve the facts.
No.
What is there, that has to be.
Yes.
Whatever discussion, meeting it is held,
Yes,
it has
my
to be
lord, I'm
accepted.
deeply obliged. But by this time, in 2016, properties have already been sold. This is way back in 2022.
Yes, so this is the meeting held in the presence for amicable settlement.
Yes, my lord, that
is 2022.
Yes. 2022.
That is Lord B is concerned, yes, Chaya Cinema. So one contention of your learned friend is this: where is this annexure at the time of entering the settlement?
My lord, may I put a question to my,
Yes.
does it matter? Does it matter even if there is no annexure? Having had acted upon it. The question lies as to where has the proceeds of the Darjeeling property gone? Has it been distributed amongst all the three groups, or has it been retained with only one particular group in which the property has fallen? Opposition to the and my lord,
yes,
what my learned junior friend very rightly points out, they have not opposed in their affidavit in opposition to this petition with regard to the lot system. They have never ever opposed. What they are saying is, I am accepting it provided there is revaluation. My submission to that is revaluation after having sold the property and having disturbed the estate cannot now take place.
Yes.
So, my lord, having had done this,
so this was also done according to you. Parties will sit further to decide the vacant portion on the backside of Chaya Cinema. So far, Chaya Cinema is concerned, it comes. You see,
it comes to my lot, and
so
that has been
that
done.
is which paragraph? That is earlier.
Yes, my lord, that in this minutes. Yes.
Page 15. 2 lots. That is, one lot will consist property around Chaya Cinema. The other lot will consist properties around Darpana Cinema.
Yes, ma'am.
And here you see, parties will sit further to decide on the vacant portion of the back side of Chaya Cinema.
Yes, and that has been done.
This is your reply. So that has been done, yes.
Yes, that has been done, Your Lordship.
From which document?
Yes, that, my lord, that it was
Supplementary
measured.
affidavit.
It has been measured.
No, that last one. I think you have filed a supplementary
Yes,
affidavit.
yes, yes. In the supplementary affidavit.
No, whether. No, what is the supplementary affidavit? Because that's where he was made regarding that.
Okay. I'm bullshit. Yes, my lord, I'll tell you, Lordship, my lord, they had once the supplementary affidavit that shows that there has been a measurement of the Chaya Cinema.
This one. Parties will sit. The last line.
Yes, yes, yes.
Hey, there is supplementary affidavit.
Parties will sit further to decide
Yes,
the
yes. There is a supplementary affidavit.
Yes, there is a
Let me see that.
There is a supplementary affidavit.
Is that not valid?
Even if it's that is
Parties will sit.
My lord, even if that is
Parties were supposed to sit. There is not whisper that it has to be measured and valued. Parties will sit.
Yes, parties will sit.
Yes.
My lord.
Okay, let me see the supplementary affidavit.
My lord, only thing is, Chandranath Barike. My lord, the only thing
No,
that your
supplementary affidavit was filed by whom?
By Chandranath Barik.
Yes, that is.
That's right today. With a supplementary affidavit.
Yes, which paragraph you have stated?
I remember, my lord, that there was one. I'll just check. Yes, Chandranath Barik, 23rd of August, June 2025. Subsequent to
that is page.
Yes, if your lordship kindly comes.
Of which page you have
Yes,
stated?
page 4.
Page 4. Yes.
Paragraph 4.
Yes, paragraph 4.
Subsequent to the meeting held on September 5, 2022, a further valuation of the vacant portion on the back side of Chaya Cinema was made at the instance of Ranjana Barik. Such valuation was conducted in the presence of myself, Ranjana Barik and Sharbojit Barik, the defendant number 3F. Inasmuch as the valuation was undertaken at the instance of Ranjana Barik, the valuation report is currently in Ranjana Barik's possession. It is humbly submitted that this honorable court may be pleased to direct Ranjana Barik to produce such valuation report.
So let us see the opposition of Ranjana Barik with regard to this.
I will. You to supplementary affidavit.
Ranjana Barikeর supplementary affidavit এর opposition টা একটু দেখি।
কোথায় আছে আবার এগুলো সব না affidavit to supplementary তো আমার দে না
Which is what? Your supplementary affidavit is when?
Yes.
Supplementary affidavit is 23rd day of June.
23rd day of July 2025.
23rd day of July.
Third day of July 2025.
Supplementary affidavit.
Yes, my lord. AO to supplementary affidavit.
No, just a minute.
AO
No, question is, you see, you were asked to provide this clarification with regard to that meeting, with regard to the backside of Chaya Cinema.
Yes.
This is supplementary affidavit to your petition. So, supplementary affidavit is affirmed when? Yes, 23rd day of June 2025.
Yes, my lord. And this is of 3rd July 2025.
3rd July is this is Ranjana Barik's.
Reply, yes.
So this affidavit in opposition is filed on 14th day of August 2025. Affidavit in opposition. So supplementary affidavit definitely, whether they have taken into consideration the supplementary affidavit or not.
Yes, my lord. This is the affidavit in opposition of Ranjana Barik to the supplementary affidavit. This is dated 3rd of July 2025.
Oh, defendant number to the supplementary affidavit.
Yes, yes.
No, here I find at the back side is this. affidavit in opposition. In my record, it is 14th day of August 2025.
No, that is affidavit in opposition to Mr. Dotto's client's supplementary affidavit.
Okay, let me see.
There's
Because you have cast some allegation that the valuation report is there.
Yes.
So let me see that.
Yes.
Where is that opposition?
Yes, my lord, I will.
এটা দেখুন supplementary affidavit.
Page 4, I have said that they have dealt it at paragraph 6.
Show it to my court officers so that they can find it out.
ওটা হচ্ছে 3rd of July 2025 of Ranjana Barik. Yes. 3rd July. Yes, my lord. May I hand over my দরকার কিন্তু এখন জাজ সাহেবকে
Because I have to.
Yes.
দেখুন এই যে Yes, 3rd day of July. That is.
Yes, ma'am. I have dealt with in paragraph 4.
Okay.
So they are
Let me
dealing.
see.
They are dealing my averments in paragraph 6.
Let me see. Yes. To the. Yes, defendant number 2B2, 2I. Yes, that is paragraph 6.
Yes. With reference to paragraph 4 of the supplementary affidavit, and save and accept what is specifically admitted herein below, I deny and dispute each and every allegation and the submission and the averments and the contentions made therein. I state and submit that in the presence of 3 parties as mentioned thereon, only survey and measurement of the land on the backside of Shah Cinema was done by licensed building surveyor of Kolkata Municipal Corporation. But as stated by Chandranath Barik in the paragraph under reply, no such valuation of the vacant portion of land on the backside of Shah Cinema was made. Defendant number 2H has made a false statement before the Honorable Court only to mislead this Honorable Court. I further deny the statements of defendant number 2H that the valuation was undertaken at my instance or that the valuation report is currently in my possession. Such is misconceived, derogatory, concocted, and malafide. I further state no valuation was made, only measurement of the land was made by LBS. The question of directing me to produce such valuation report does not arise. I hereby submit that none of the parties have ever stopped the defendant number 2H, Chandranath Barik, to value the said property. Copy of the survey and measurement plan is annexed here to and marked with letter C. My lord, may I pause here for a moment?
Annexure C. So how have you dealt that? You have accepted that in your reply? That yes, there is no valuation report?
No, we have said that we have, the measurement is there. Just a minute.
Because your allegation is this valuation report, every report is with her. But
valuation report is, they have said that it has been measured, but there has not been any valuation report.
So you have accepted that?
No, we have not. May that as it may, my lord, if I may, আমাদের reply to the 6, paragraph 6. On the 6, paragraph 6. No, it is from theirs. It is theirs. Correct. Affidavit reply to my lord, Lordship, kindly give me one moment. There are so many affidavits, supplementary, this, that, and all. Yes. Your Lordship will kindly take up the affidavit in reply affirmed by Chandranath Barik on 7th of July 2025.
So this is the affidavit. No, I was going through the affidavit in reply where you have annexed different documents. That is, yes, affidavit in opposition, I think. Corporation affirmed by non-union body. So you have affirmed one affidavit in reply on 23rd day of April 2025.
No, my lord, with respect, these
No.
are all supplementary affidavits. My lord, the supplement,
Affidavit in reply affirmed is with regard to the original petition.
yes, but this,
23rd April 2000, that is with regard to original one.
my lord,
And this is with regard to supplementary.
supplementary,
That
this
is
would be
7th day of,
July 2025.
that is page,
Yes, yeah, paragraph 6.
yes, paragraph 6, para 8.
Para 8 is dealing with paragraph 6.
Yes.
If I may just read out that. With reference to paragraph 6 of the said affidavit, save and accept what are matters of record and what would appear from a true and proper interpretation thereof. I deny and dispute each and every allegation made therein. I repeat and reiterate the statements made in paragraph 4 of the supplementary affidavit and deny and dispute each and every allegation contrary thereto and or inconsistent therewith. It is denied that defendant number 2H has made any false statement before the Honorable Court. It is denied that no misconceived or derogatory or concocted or malafide statements and averments were made at the behest of the defendant number 2H. I repeat that the further valuation was done at the instance of the defendant number 1E and copy annexed for such measurement is not legible and no revaluation is required as the valuation was done on prior occasion. In considering all such valuations, lots were prepared and approved by the parties. My lord, may I pause here for a moment?
Yes.
My lord, put a question to myself. At this stage, would it be necessary for my lord to go into this?
No,
That is my
see,
question.
just-
Why?
First ascertain the facts, thereafter apply the law.
I'm
What is the present position?
I'm obliged.
What is done, what exists?
I'm obliged. I'm obliged.
Yes. Further valuation was done at the instance of defendant number 1E.
Yes.
And copy of such measurement is not legible
Yes, the valuation report.
and no revaluation is required.
Measurement, the measurement report. The measurement report. My lord, your lordship will kindly see, at the cost of repetition, my lord, I say, that all this Chaya cinema, valuation, measurement, all this is being done way back in 2022. My lord, would your lordship take all these facts into consideration when in 2016 there has been acceptance of the lot and selling of a property and the proceeds having been utilized by one particular lot? My lord, your lordship will kindly consider that. Having had accepted in 2016, can I go back in 2022 and say that you get that property measured that has come in your lot? Can I do that, my lord? I put a question to myself. That would amount to approbation and reprobation.
That was not done because the party sat for a discussion. Had the party not sat for a discussion, the case would have been otherwise.
My lord,
Or there would have been
what
the
is-
case. The matter ought to have been contested.
My lord, may I just make an
Suppose
addition
the
apropos to
party
that?
would not have sat, but the party has sat.
My lord, the parties did sit.
Yes, yes.
But my humble submission would
So
be,
far, this contesting party is concerned.
yes, my lord, the parties did sit. But having had already complied with whatever has happened in 2004,
Yeah, that is twofold arguments. One is the discussion terms, and the other is the Act 2016.
I'm
Not a
obliged.
one. It is a not one contention. Twofold
my lord,
contention.
I'm pressing upon the act. The
Act as well as you see the terms.
And what did they, my lord, agree to sit with? Parties will sit further to decide the vacant portion on the backside of Chaya Cinema. My lord, backside of Chaya Cinema has fallen on my lot, at my lot. So that is allotted. Even if the parties sit, the allotment cannot change when they have accepted it. That is what your lordship will kindly consider.
So the only the bone of contention is the valuation, what it stands now.
What they are saying is to revalue the
Yes,
entire.
that is the bone of contention.
My lord.
That there is no settlement
until entire property is
Yes.
revalued.
And it is a conditional acceptance, and the bone of contention is revaluation.
Revaluation, my lord, of the entire properties.
Yes, all the lots.
All the lots, entire properties, when the entire properties do not exist. I will go to the extent of that. The entire properties do not exist. One property from their lot, one property from their lot do not exist. It's gone into some third party's hands. And my lord, there is another property, as has been indicated by my learned senior friend. Your lordship will kindly come to page 14. Page 14 of my petition.
Page 14.
Hemanto Mukherjee, sorry. Page 14, my lord, I have shown Darjeeling property.
Page 14.
Just before that.
Yes, that is there.
No, my lord.
Page 14 of your reply.
No, page 14 of my petition.
No, page 14. No, you have referred to that representation made for mutation.
Yes, that is there.
Yes.
My lord, apart from Darjeeling.
Yes, Lord B.
Apart from Darjeeling property, P466 Hemanto Mukherjee.
Yes.
That has also been distributed amongst the defendant number 1 group
by registered deed of gift.
Okay, that is R and S both.
Yes, by registered deed of gift.
Okay, that is R and S, and in this side it is.
All this is being done, and now revaluation of what?
On 17th May 24.
As late as on 17th May 2024.
So R and S, and here is B. Lord C, it is B.
Yes.
P20.
P20, yes, my lord.
So these are the properties which do not exist.
They do not exist. It is not only that they do not exist. Why do they not exist, my lord?
By the alienation.
By their alienation, which means acceptance. Which means acceptance. The legal conclusion, my lord, with deepest of respect is, I've accepted it. Having had accepted, cannot not go back and put a spanner in the work. My lord, this is one, my lord, factor. And with regard to the legal aspect, my lord, if I may just rely upon the judgment, my lord, once more.
No, because judgments you will give your compilation. Along with your written notes and list of dates, you will give your compilation.
I will, my lord.
All of you.
The judgment, the same judgment is being relied upon only for the purpose, my lord, of showing one particular line that, my lord, nature of the present suit. I'll just read out one line. I'll not trouble your lordship.
Yes.
My lord, the judgment which has been referred to by my learned senior friend, AIR 1935 Calcutta, my lord, page 439. My lord, my learned friend has read it out in extenso. Mr. Ghosh has also relied on this. My lord, I am just, my lord, relying on one particular one line. The administration, my lord, page 45. The administration consists, generally speaking, in the payment of the funeral expenses of the deceased, in the payment of debts and legacies, and in the collection, realization, preservation, and distribution of the assets. My lord, I am putting all my emphasis in the distribution of assets. What am I wanting here? My prayers are that preliminary decree be passed in accordance with the lots that has been accepted by the parties. And in accordance with the lots means how the entire asset is going to be distributed, as has been agreed to by the parties. I'm not wanting anything more. Mr. Rupa Ghosh has been making submissions that how can a final decree be passed without a preliminary decree. I'm not wanting a final decree. My lord, I will also rely on the provision of the Code of Civil Procedure. Lord, you will kindly see my prayers in the petition. That is exactly what I'm wanting. Yes, it's a summons, my lord, master summons I have taken out. The Lord will kindly see. I'm not wanting a final decree.
Yes,
Prayer.
Hey, master summons to din to ekটু.
I am supported by the provisions of Order 20, Rule 20.
Yes, preliminary decree.
Yes, a preliminary decree be passed in terms of the admitted lots by the parties, more particularly described in paragraph 14 herein and in annexure A to the affidavit in support of master summons. Then, my lord, prayer B. Prayer B is only with regard to the dwelling house, because your lordship has seen that half of it has to go in one lot, the other half has to go in another lot. So commissioner has to be appointed. A commission be issued to an advocate with a direction upon him to partition the residential property 194 Vivekananda Road, as indicated in lots A and B, as agreed by the parties, more particularly described in Annexure A to the affidavit in support of master summons, and thereafter final terms of settlement be filed in court for final decree in the suit. So I'm also praying for a preliminary decree. After the preliminary decree, after the report of the commissioner, then the final terms of settlement will be filed.
No, if a preliminary decree is passed, you see what happens. A time is given for the parties to settle. If settlement fails, then commissioner is appointed.
With deepest of respect.
That is the usual procedure in a partition suit. But here there is no scope of such settlement.
My lord, no, my lord, with deepest of respect. Maybe
Yes.
I have not been able to convey my.
No, you see, suppose decree prayer A is allowed, and thereafter parties are granted opportunity to settle as per the preliminary decree there by meets and bounds. So if they fail to arrive at a settlement, definitely court has to appoint a commissioner.
My lord,
That
with
is the
respect-
usual procedure which is followed.
My lord, with respect, here, my lord, if your lordship kindly sees the prayer. Prayer B is only with regard to Vivekananda property, not entire property. Vivekananda property, my lord, one half goes to one lot and the other half goes to another lot. So that is the reason why.
Vivekananda property demarcated as lot A and lot B.
Yes.
One property in two lots.
I am obliged only with regard to that, because someone has to be there, an independent person, to demarcate the lots, that this portion will fall to lot A, this portion will fall to lot B, because lot A and lot B are all determined. That covers, prayer A covers that. But in order to give a complete picture and complete effect to prayer A, prayer B is necessary, or else prayer A will remain incomplete with regard to that particular portion. So they go both go hand in hand. After this effort, then, my lord, the final decree comes into effect. Absolutely. After this effect, the final decree comes into effect. So these two, my lord, has to go hand in hand, or else it will not be a complete picture that will come into being.
So after filing up the report, the final decree has to be passed.
I am deeply obliged. Yes, yes, yes. My lord, may I now? Yes. Order 20, Rule 13. My lord, may I now rely on Order 20, Rule 13 of the Code of Civil Procedure? That this is also there in administrative suit. The nomenclature, my lord, with deepest of respect, cannot stop.
Yes.
Order 20, Rule 13, my lord.
Yes.
Decree in administration suit. Where a suit is for an account of any property and for its due administration under the decree of the court shall, before passing the final decree, pass a preliminary decree ordering such accounts and inquiries to be taken and made, and giving such other directions as it thinks fit. So, my lord, your lordship, my lord, there are three things that the court has the power to do. Preliminary decree ordering accounts and inquiries to be made and taken and made, and, my lord, giving such other directions as it thinks fit. So in this particular case, your lordship would think it fit, considering that what has passed and considering what has, my lord, transpired between the parties, to give a direction with regard to preliminary decree for the admitted lots. Well, a very wide scope, as is fallen from my learned senior friend, that this, or else, my lord, this would not have been added, giving such other directions as it thinks fit. So this is where, my lord, the subsequent events are to be taken into consideration. This is where, my lord, natural justice comes into being. This is where, my lord, where the parties want to settle the dispute once and for all, that your lordship's intervention is necessary.
It is long litigation.
My lord, I'm deeply obliged to your lordship, my lord, for giving us such patient.
Thank you. And probably, you see, because next 2 weeks this bench will not sit, I'm keeping it after vacation for only filing the written notes of arguments, list of dates and the compilations of the decisions and documents.
We cannot be more obliged to your lordship for this indulgence that your
Anyway,
lordship has given.
all of you have made your endeavor,
Yes, my lord.
assisted the court also. Yes, record an order. Learned advocate for the petitioner, defendant number 2 series,
my lord,
have completed his submissions in GA 23 of 2025. The hearing of GA 23 of 2025 is concluded. Stop. The learned advocates for the parties are granted opportunity to file written notes of arguments along with the compilations of the judicial decisions and list of dates on or before. I'm keeping it on 6/1
As your lordship pleases.
after vacation.
অনেক দেরি হয়ে যাবে গো।
6 January.
No, no, 6/1.
January.
The more your lordship is being indulgent, the more
Well, keep it 6 January. We are getting enough time.
I'm leaving it to your lordship.
Today we are only on 9.
550 যেতে হবে।
Okay, then let me do one thing. Shall I? 6th. Then let me keep it on 12th of January.
As your lordship please.
12/1/2026 at 12 এ ছুটি থাকবে।
Oh, 12 January will be
13/1/2026 at 4 p.m. 13/1/2026 at 4 p.m. under the heading to be mentioned.
4 p.m.
I'm deeply obliged.
Yes, you
3:30, my lord, would be safer. Because, my lord, you never, after such a long winter vacation, there would be many 3:30s.
No, I'm 13th, I'm keeping it.
Yes, but fourth, my lord.
No,
the
because
possibility-
at that time, all of you will be free.
No, we are free. Lordship has not understood us. Well, 3:30 is a very uncertain.
We may have to lose many of our colleagues.
It is 3 o'clock, 2 o'clock, only for the purpose of filing of the notes.
Okay, 13/1/2026 at 3 p.m.
Deeply obliged. May I take your lordship's leave?
Yes,
my lord?
thank you.
One thing, my lord,
Yes.
the remuneration of Mr. Adlitam remain due not 1,53,000.
Okay, I shall pass it on the next day because when I take the written notes of arguments, I shall pass on that order on the next day.
This is what you
No, no, no. Written notes of argument. Okay. Usually the nouns and list of dates. এগুলোকে ঠিক করে রেখে দিন, এগুলোকে ঠিক করে মানে কোনটা এফিডেভিট, অপোজিশন, সাপ্লিমেন্টারি এফিডেভিট।
ফাইল এসছে এসআর থেকে, হ্যাঁ এসআর থেকে ফাইল এসছে, ওই পাঠিয়ে দিয়েছে ফাইল, কয় পাঠিয়েছে বলছে কত তারিখ যেন।
Yes, both of you see that the remuneration is paid, okay, of the administrator. No, no, your learned friend is here. His remuneration is unpaid. You please see to this. I've not passed any order. On the next day, I shall pass orders.
শুক্রবার হবে, শুক্রবার মানে আগে শুক্রবার।